It will appear as to be mentioned.
Lordship, may I mention a matter, Lordship? Item number 190 of today's list, Lordship. The matter was taken up on 18 July, Lordship. Your Lordship has been pleased to direct the matter will appear under the heading motion, Lordship. This is a matter with regard to the Lordship. The matter is pending before the controlling authority, and the petition and the respondents are not paying the gratuity, Lordship. Lordship,
Yes,
remember,
yes.
Lordship, the matter has gone down in the list, and now
It has not gone down in the list. It is by the way the computer section has filed it. It is not physically done. It's automatically done. It's
Lordship,
not,
kindly,
nothing to do with us.
Lordship, kindly
Please
take
do
it
not
up.
mention it for that reason. Yes.
Lordship, I cannot hear you.
Only for naming.
You may not have given your appearance.
Name was only but not name.
কে ছিল নিয়ে জিজ্ঞেস করো তো কে ছিল কে নিয়েছে ডিকটেশনটা কে নিয়েছে you please give the slip. We will have to look into it.
Yes.
Whether the name was actually given or not, what has happened, we'll look into it.
Monday person is going to retire, was application only for one line order. Grant leave to submit the report. 251 item.
No, I will have to look into it. I cannot do anything. I have to first hear the matter. Otherwise, it's not possible.
Monday he retired, everything gone. Only
What will everything go? Why will everything go? Yes. Yes.
My lord, this matter,
Yes.
serious charge against this.
That I have understood, but without hearing, why should I pass that order?
It's not possible, my lord. I also understand that. But
And what will go? Why will everything go? Why is he saying everything will go? This is serious charge. This relates to money. So why is he saying that everything will go?
if he's going to retire,
So
if he retires, then I won't be able to take any disciplinary action against him.
the disciplinary action has already been taken.
But under the rules, my lord, I cannot do anything, my lord, if he retires in the meantime.
Why the order is already there? You just have to publish the award, publish the order of penalty, and that has been kept in abeyance by order of court. I do not understand why he is submitting that everything will go.
There is some lack of communication, my lord. I am also very sorry, my lord.
Please talk to
My lord,
Mr. Kumar. All right.
If necessary, may I have the leave to mention it?
Yes.
Lordship, kindly take it up Monday, Lordship.
No,
Please.
sorry. I
Lordship,
can't
kindly
allow-
see your Lordship's order
No,
last.
I cannot allow upgradation. Yes, doctor.
No, Lordship, no upgradation, Lordship. Lordship directed the
I
matter.
cannot allow upgradation.
Lordship directed the matter will appear under the heading motion, Lordship. Kindly see your
It must be returnable motion. Is it not appearing under the heading returnable motion?
190 of the Lordship.
So,
Lordship. Lordship,
It has not been
respondents are
done
not-
manually, madam. Please try to understand. It has not been done manually.
I am for the Union of India in this matter, my lord.
Speak to central government employees.
Group 6 na group 3?
This is group 6, my lord.
এটা কবে অবধি আছে? না ইন্টারিম অর্ডারটা কবে অবধি? আসুন।
Officially passed on 31st of May 2021.
The interim order
My lord, it was in the date.
extended by an order dated April 25, 2023 is further extended till October 31, 2023. No, October 31, এটা তো তখন পুজোর ছুটি, is extended till November 20, 2023. Stop. Next. এটা তো already run করছে monthly list এ।
Yes,
কোন-
my lord, it was,
হ্যাঁ, ঠিক আছে, server copy.
my lord, it will appear.
কিন্তু can 1 with can 3 দেখুন কতগুলো can আছে।
My lord, one respect to submission, my lord. We have made excess payment, but now, my lord, onwards, my lord, lordship kindly restrain, my lord.
Yes, next one. Yes.
I'm appealing for the petitioner, my lord. In this matter, my lord, on earlier occasion directed for exchange of affidavits. That period is over, my lord. I'm led by Mr. Oh, yes, sure. My lord, that period has expired. Now, my lord, I have mentioned this matter. They are not filed their affidavit in opposition, and I beseech my lord in this matter My lord, all records are before me, lord, annexed to the writ petition. My lord, it's after a remand order passed by this honorable court, they have passed a fresh order. My lord, despite not taking the in its proper perspective without any reasons.
Yes, that will be a separate cause of action. Now, what do you want today?
Well, today, my lord, kindly directs the matter to be heard out because there is a direction for affidavits. That period has expired.
The period of
Let the
period
matter now
stipulated for exchange of affidavits have
affidavits.
expired.
Yes, expired.
You are saying there no interim order has expired?
No, no. Period, my lord. My lord's order directing
You
period of.
started your submission with
My lord, sorry, my lord, I could
with
not.
the fact that the interim order
No,
has
No,
expired.
no, 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 no. My lord, interim order, sorry, my lord, if that has gone away. My lord, the order, my lord, of my lord, directing exchange has expired. Affidavits.
Ashu. Since no affidavits have been filed, despite the time stipulated for exchange of affidavits, and no extension has been prayed for today on behalf of the respondents. Let the matter appear as marked for orders on September 6, 2023. For orders are September 6, look at bolder for it.
My lord, item number 3, my lord, I am for the petitioner, my lord. There was an interim order of your lordship dated 19th May 2023. My lord, the interim order is still 31st July 2023. There was a direction to file affidavits, but we have not received any affidavits on behalf of the opposite parties.
Milady, I appear for the West Bengal Zoo Authority.
You are for the respondent?
Yes,
Yes.
respondent
main
number
contestant.
9, led by Mr. Kishore Datto.
That is very good. Why have you not filed?
Milady, we have preferred an appeal.
So that's
can
why you
see-
will not file your affidavit.
Kindly grant us leave to file the affidavit for at least for 10 days.
You have preferred an appeal, I have understood, but the matter is before the single judge. You have decided not to file any affidavit. When have you preferred an appeal?
Before Honorable Justice Tapobrata Chakraborty and
Yes, when?
when
I have not asked you before whom.
কোন ডেটে ফাইল করেছিস জুলাই আগস্ট সরি আগস্ট আছে
June.
কবে
10th of July, Milady.
10th of July. Now
In the
this
meantime, there
order
was-
is passed on 19th of May. You have filed an appeal on 10th of July after the period stipulated for filing of affidavit. Because I have directed the filing of affidavit by the respondents by 16th of June.
Yes.
And now you come and say that you have filed an appeal. Is there any stay in the appeal?
No, Milady, but we have tried our level best to
Then
get the-
why have you not filed your affidavit?
that is, I apologize for that. Milady, kindly
Ashu-
give us liberty to file the affidavit.
By an order dated May 19, 2023, the transfer order dated May 3, 2023 was kept in abeyance till July 31, 2023, full stop. Let such interim order be extended till November 30, 2023, full stop.
my lord, the release order was also kept in abeyance.
Wait, I am
Extremely
getting
sorry,
to that.
extremely sorry.
The release order dated May 3, 2023 was also kept in abeyance till July 31, 2023, full stop. Let such release order be kept in abeyance till November 30, 2023, full stop. Next. The respondents were given liberty to file a short affidavit by June 16, 2023, full stop. It is now submitted on behalf of the respondents that no affidavit was filed, since the respondent authorities have preferred an appeal. Full stop. Such appeal was preferred on July 10, 2023. It is submitted, that such appeal was filed on July 10, 2023. Full stop. Next. Therefore, it is apparent that such appeal was filed after the expiry of the period stipulated for filing of an affidavit by the respondents. Next. It is also submitted that no order of stay has been passed in the said appeal. Full stop. Therefore, this court fails to understand why the respondent authorities have not complied with the directions of this court in relation to filing of affidavits. Full stop. Next. However, in the interest of justice, this court extends the time to file affidavits to time to file an affidavit in opposition by August 11, 2023. Full stop. Reply, if any, by August 25, 2023. Full stop. Next. Let the matter appear in the monthly list of September, bold, 2023. এটা bold হবে as marked for hearing, bold. Server for.
I'm grateful, my lord.
As per my lord's direction, I have served the cop.
Yes, he is appearing.
Sorry, Sir Lordship. Lordship, in this petition, I have a simple hardship to pay interest on the delayed payment of my terminal benefits.
Please speak on the microphone, madam.
My lord, I am just paying for the interest on the delayed payment of my terminal benefits, my gratuity and my leave encashment, Your Lordship. Your Lordship had retired from service from West Bengal State Irrigation Corporation Limited. on
Yes.
31st
No, my lord, I file, my lord, affidavit in opposition, my lord, because he is not entitled to interest, because the latches of the writ petition, my lord, I file, my lord, affidavits, my lord. Either, my lord, form of.
You filed affidavit, money. You have not read the previous orders passed by this court. What are you doing?
My lord, what has.
Orders were passed on 13th of April.
Yes, my lord. Lord, I appreciate, my lord, due to change of this
You
circumstance.
know what, due to the change? On April 13, you should have brought
My
your
lord,
report
within
and
1
affidavit
week, my
today.
lord, I file, my
No,
lord.
no, you should have brought it today. Why are you harassing them?
Not harassing, my lord. My lord, sought affidavit.
I have directed you to file within 24th of April.
Definitely, my lord,
Ashun. By an order dated April 13, 2023, this court directed a report on affidavit R capital, A capital, to be filed on behalf of West Bengal State Minor Irrigation Corporation Limited, within bracket WBSMICL, bracket closed, within April 24, 2023, full stop. Now, on several occasions, accommodation was sought for on behalf of the Learned Counsel appearing on behalf of WBSMICL, full stop. Such prayer was considered and allowed, full stop. However, comma, today also, no report on affidavit is being filed on behalf of WBS MICL, full stop. Next. Time to file such affidavit, report on affidavit is extended till August 11, 2023. Upon payment of costs assessed at rupees 2,000, full stop. Next. Exception, comma, if any, by August 25, 2023, full stop. Next. Let the matter appear for further consideration under the same heading motion, bold, on August 30, 2023. Hold. Server copy. Without reading the order, you come and you are saying that I want to file an opposition. The,
No, my lord, kindly appreciate, my lord, kindly, my lord.
why have you not checked up the orders?
Yes, my lord, I checked, my lord.
Yes. Next.
Madam, I'm appearing for the petition. Service. This matter relates to recovery of the alleged overpayment amount to the tune of rupees 1,05,663 from my salary from November 2019 to January 2020. And I retired from service on 31st of January 2020 as Tor Khalashi from West Bengal State Mine Irrigation Corporation Limited.
They have filed the report.
No, Your Lordship, nothing. This is the direction, Your Lordship.
My lord, kindly, my lord, I have, my lord, I satisfied before your lordships, my lord, my lord, kindly, 1 week's times, my lord, I have, my lord, received from report, my lord, yesterday, my lord, during, my lord, this is not prepared by.
Ashwin. Time to file report on affidavit is extended till August 11, 2023, full stop. You want to file an exception?
No, Your Lordship.
Let the matter appear for further consideration under the same heading motion bolded on August 16, 2023.
August 16, Your Lordship. Lordship, I am for the petition. Evidence of service. Your Lordship, this is also the recovery matter. They have recovered an amount of rupees 3,84,576.
I am passing same order like the
Lordship.
previous one.
Lordship,
It will appear on August 16.
Lordship.
I'm for the petitioner, in this matter, an amount of 1,13,615 has been recovered from my salary, just before my retirement in December 2019, From September to December, they have recovered an amount of 1,13,615 from my salary, on the alleged ground of overdraw, for wrong fixation of pay, where there was no misrepresentation on my part.
Yes, please speak on the microphone. I can't hear
There
you.
was no misrepresentation on my part.
Yes. You want to file a report?
File.
Ashu. Let a report on affidavit be filed by the West Bengal State Minor Irrigation Corporation Limited, within bracket WBS MICL, by August 11, 2023, full stop. Exception, if any, by August 25, 2023, full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on September 6, 2023.
Same matter, 2,200.
Same matter,
Same matter.
same order.
Time for the petition. As per the payment of gratuity act, my gratuity cannot be withheld under any circumstances. I will show your lordship, my gratuity has been withheld only on the plea that I took a loan from a cooperative bank and the bank claims that some more payments are due. Now, your lordship kindly come to section 4(6).
Why will I come to section 4(6)? Can you tell me? I have already recorded that in my previous order.
Yes, yes.
Why
And
shall I again spend judicial time on that?
then we look section 9 also penal provision, that is. For contravention of any of the provisions of Gratuity Act, there is a penal provision.
Yes, Mr. Sen, you were permitted to take necessary instructions.
My lord, in instruction that I have, my lord, my lord, that, my lord, all the time they said that my lord, the higher authority, my lord, sought instruction from my lord, the lower, that is the accountant, and then this is going on. Now, may I tell today one thing, my lord? If your lordship, my lord, agree to the submission of my learned friend that yes, so far this matter is concerned, because I do not know when the record come to the head office and then I will get instruction. But the fact is, yes, my lord, so far this matter is concerned, my lord, that even today I also, my lord, hang up. My lord, so far this matter is concerned, my lord can pass the order. I think, my lord, but not as on the basis of my submission, because the CSTC has nothing to do with regard to, it is a fact, with regard to the loan, my lord, obtained from the cooperative society. Only on the basis of the letter from cooperative society, the gratuity has been withheld. My lord can, my lord.
Have you put in the disputed amount with the controlling authority?
No, my lord,
have you done your obligation as per the act? That instruction you have to give me.
Yes, that my lord, then lordship kindly give me 7 days time maximum.
No, not anymore. I have extended time to get your instructions on the last
So I
occasion.
sought for instruction, my lord, repeatedly.
Yes. You have prayed for time, I have given it to you.
That's true. That is true. That is true, my lord. But whatever they have, my lord, realized out of his, my lord, the salary month by month deduction, that has been deposited.
Of Calcutta State Transport Corporation, within bracket CSTC bracket closed, on June 30, 2020, full stop. The grievance of the petitioner is that despite expiry of almost 3 years, no, of more than 3 years, the gratuity dues of the petitioner have not been disbursed yet. Full stop. Therefore, the petitioner had no recourse but to approach this court in its high prerogative free jurisdiction. Full stop. Next. Mr. Ghosh, learned counsel appearing on behalf of the petitioner, submits that during the service tenure of the petitioner, a sum of ₹90,000 was taken on loan from the employer. Full stop. Next. By an order dated April 28, April 22, 2008, passed by a coordinate bench of this honorable court, the respondent authority was directed of this court, the respondent authority was directed to take appropriate steps for recovery of the admitted loan amount of ₹90,000. Full stop. For the disputed loan amount of ₹3 lakhs, the authorities concerned, 3 lakhs, the authorities concerned were directed to take a reasoned decision. Full stop. Next. Pursuant to the order passed by the coordinate bench on April 22, 2008, the chairman CSTC took a reasoned decision. Full stop. In the reasoned decision, it was held that the amount of ₹90,000 within bracket undisputed loan amount, bracket closed, along with interest, should be repaid by the writ petitioner. Full stop. In the event the writ petitioner failed to repay the said loan amount, comma. The same would be realized directly from his salary by way of monthly installments until the settlement of the amount, comma, in its entirety, full stop. It is submitted on behalf of the petitioner. Next para, that the said the admitted loan amount of 90,000 along with accrued interest has been recovered by CSTC by way of monthly installments, full stop. Such a position is not in dispute, full stop. Therefore, comma, it is contended that there is no legitimate reason for withholding payment of gratuity dues of the petitioner, full stop. Next. Mr. Sen, comma, learned additional government leader, appears on behalf of CSTC, full stop. On June 28, 2023, comma, when the matter came up for initial hearing, he prayed for time to take necessary instructions in the matter, full stop. Time to take necessary instructions was also extended till July 12, 2023, full stop. Now, on July 12, 2023, full stop. However, such instructions are not brought on record even today, full stop. Next. On behalf of CSTC, it is submitted that there is a dispute with regard to non-payment of loan of rupees 3 lakhs to Howrah District Central Cooperative Bank Limited, full stop. In view of pendency of such loan,
Page 20.
the gratuity dues of the writ petitioner were not being settled, full stop. An administrative order dated February 14, 2020, issued by the Administrative Personnel Officer, Howrah Depot, CSTC, was referred to. Now, is referred to, full stop. The petitioner was directed to bring necessary documents for resolution of the dispute regarding non-payment of the loan, regarding non-payment of the disputed loan that is purportedly payable to the cooperative bank, prior to the disbursal of the gratuity dues, full stop. Next. By an order dated June 28, 2023, this court recorded its prima facie view that the employer cannot withhold the gratuity dues of a retired employee unless the employer suffered any loss due to the act / misconduct / negligence of the retired employee, full stop. Next, section 4 within bracket 6 of the Payment of Gratuity Act, 1972 is reproduced here in below. Section 4(6) টা করে দেবেন, এখানে আছে, করে দেবেন এখানে। Next. Admittedly, the cooperative bank is not the employer of the petitioner. Full stop. Admittedly, the amount of loan taken by the petitioner from the cooperative bank is also in dispute. Full stop. Next. Therefore, this court is of the view that there was no legitimate reason for CSTC to withhold the payment of gratuity dues to the petitioner stroke retired employee. Full stop. The action on the part of the CSTC is illegal and arbitrary and incolorable exercise of power. Full stop. Furthermore, it could not be submitted on behalf of CSTC today whether the statutory obligation of depositing the disputed amount of gratuity with the controlling authority has been fulfilled by the employer under the 1972 Act. Full stop. In view of such lack of instructions, it is deemed, italics by this court, that the statutory obligation has not been complied with by the employer stroke CSTC. Full stop. Therefore, this court directs payment of the gratuity amount within a period of 1 month from the date of this order, along with interest at the rate of 6% per annum from July 1, 2020 till the date of disbursal of the entirety of the dues of the petitioner. Full stop. Next, this court has not appreciated the harassive attitude of the employer with regard to its retired employee. Full stop. Next. With the directions aforesaid, with the directions and observations aforesaid, WPA 13633 of 2023 bolded is disposed of bolded. Server copy certificate.
Get only when the rate of interest has increased in the bank, when rate of interest now is 8% for the senior citizens. But the only thing may I submit one thing, my lord. Whatever observation, rightly, I am not on that. Instead of colorable exercise, lordship, kindly have a non-application of mine, lordship, kindly.
Yes.
Get it deeply honest.
Well, this is a case of overdrawal after retirement. The petitioner was working as a water transmission assistant.
I'll give them time to file a report on affidavit.
Yes, yes.
Ash.
I mean, they had actually he had already, it's already there in their letter that in 2018 he had retired. And this letter
You
comes.
have to file a
Yes,
report
yes,
on affidavit
absolutely.
whether you have given any undertaking
Yes, yes,
before your
yes.
retirement, that because
Yes,
usually
yes,
they
yes.
annex an undertaking. into the report.
Absolutely. The process that your lordship adopts is so good that everything comes up the next day. This is a fantastic process, my lord.
The case of the
ठीक है,
petitioner
Charlie.
is that an amount is sought to be recovered from
80,590.
amount of rupees 80,597
Yes.
has been recovered from the retirement benefits of the petitioner, illegally and arbitrarily by the employer, West Bengal State Minor Irrigation Corporation Limited, within bracket WBS MICL, bracket close full stop. The petitioner has also paid for interest on the delayed payment of retirement benefits. Full stop. Next, the petitioner worked as an operator with WBSMICL. Full
But
stop.
he was working as a water transmission assistant. I'm sorry,
Paragraph 4.
water transmission assistant. When he retired, my lord, when he retired. He retired as an operator, he was working as
Yes,
one.
operator.
I'm
He-
sorry, my lord. I'm sorry.
He was superannuated from his service with effect from July 31, comma,
तो तुम तो बोलो retirement तो बोलो ना।
2018. Full stop. By a memo dated January 18, comma, 2019, the managing director, comma, WBSMICL sought to recover the said amount of rupees 80,597 as the overdrawn amount from the retirement dues of the petitioner. Full stop. Next. Considering the submissions made on behalf of the parties, this court is of the view that justice will be subserved by directing the respondent number 4 or any other authority delegated by him to file a report on affidavit on the issue why the terminal benefits have been belatedly disbursed, and also on the issue why an amount was deducted from the terminal benefits of the petitioner as overdrawn amount. Overdrawn amount taka italics e korben. Full stop. Let such report or affidavit be filed by. How long will you take? Give me a reasonable date.
Yes, within 3 weeks, my lord.
3 weeks.
By August 18, comma 2023. Full stop. Exception, comma if any, by September 1, comma 2023. Full stop. Parties are directed to exchange advance copies of their affidavits. Full stop. Next. Let the matter appear for further consideration under the same heading motion bolded on September 6, comma 2023. Bolded. Full stop. So
Grateful, my lord. Grateful. My lord, let the affidavit of service be kept with the record. I take to Nian kindly. Next matter to the. Next matter to the. এটা দিয়ে দাও Yes, well, this is my application against similar matter. Here, the overdraw amount which they have deducted is 2,26,373 at page 18. At page 18, my lord, just before the signature of the managing director.
date of retirement April 30, comma 2018.
My lord, may I seek for an apology, my lord? This petition has been made by the widow and the others because he has died in the
Retirement
meantime.
of the
Yes, my
petitioner's
lord.
husband is April 30, comma 2018.
Take to affidavit of service to kindly.
Retirement dues
Thank you.
belatedly disbursed on August 2, comma 2019. Full stop. আচ্ছা, petitioner number 1 করুন। কারণ অনেকগুলো আরো petitioner আছে। Amount of terminal benefits. with
2,26,373, madam.
73. Full stop.
দেখতে পাচ্ছি তো, ভুলভাল বেরিয়ে নাই।
Impugned order হলো July 25, 2019. Yes.
Grateful, madam. Grateful.
You are appearing for Mr. Samanto?
But I'm for the state.
State.
Madam, in this matter, is the returnable date is the same, madam. Same date, returnable date.
My lord, I am
You are appearing in,
petitioner, my lord, I am for.
then you are saying
My lord,
same.
item number 223.
Yes,
I am
he has said same on your behalf. He submitted in 222, now he is submitting in 223 also. All right.
Well, here, my lord, from the terminal benefit, my lord, the amount deducted on the ground of overdraft. Only one thing, my lord, in a similar issue, my lord, some of the employees approached before this honorable court. My lord, the page, my lord, 14, I have annexed the order passed the honorable coordinate bench in this similar issue. My lord, the honorable court, my lord, order dated 12/12/2019.
Yes, but this is at the first stage.
Yes,
At the first stage, how can
my-
the facts of this are simple?
my lord.
One has to
No,
go into that.
Yes, my lord, they can. Only, my lord, the report is required.
Ashun. Superannuated as electrician. Age of superannuation, date of superannuation, March 31, 2017. Received retirement benefits on December 18, 2018. Full stop. Sum of rupees 1,71,097 not disbursed, retained as overdrawn amount. If you speak like that, I can't hear you. Why are you whispering?
My lord,
Yes.
yes, my lord, kindly fixed another day. My lord,
No.
problem is, my lord, all our matter is on the.
All that I can't do it. It will be as per convenience of the court, not as per your convenience.
No, my lord, my lord, convenient, my lord,
take up all these group 1 matters on Wednesdays.
my lord, grateful, my lord. Same, my
Same, but let me see. Look at the facts before looking at coordinate benches order.
lord. This is a similar.
Ashun. Retired as operator. Superannuation on January 31, 2018. No, January 31, no, October 31, zero টাকে January, October 31, 2018. Payment retirement dues paid on July 25, 2019. Rupees 2,42,155 deducted as overdrawn amount.
Six.
My lord, I am appearing for the state, my lord.
Same is, same one.
Same issue, my lord.
আসুন। Operator. Date of retirement, May 31, 2018. Terminal benefits released on July 25, 2019. Full stop. Overdrawn amount 2,08,502.
Number 26 or
হ্যাঁ দাঁড়ান এসে গেছে তো 226 অলরেডি। Operator. Date of retirement, June 30, 2017. Overdrawn amount 1,75,832. When have you received the payment?
my lord. My lord, paragraph 9, page 5. Your petitioner,
Yes, when, date. I have read paragraph 9.
That, my lord.
So from, you're claiming 10% interest.
My lord, kindly comes to page 16, my lord, in the representation of there 5/7/2019.
Why have you not stated in the writ petition? You are praying for delayed payment of the interest. Where is the date of payment in your prayer?
My lord, that amount, my lord, received on July 5th July 2019.
Amount received on July 5, 2019. হয়ে গেছে।
27, my lord, the petitioner is the, my lord, the widow of the
Petitioner widow of the deceased employee. Husband retired from service on December 31, 2017. Full stop. Worked as an operator. Full stop. Received the amount on July 15, 2019. Now over here, you have not said how much amount has been deducted. Every writ petition you are filing the way you want. Where have you said the amount that has been deducted?
my lord, in the last page, my lord, the representation, my lord. আমি গ্র্যাচুইটি বাবদ ও লিভ স্যালারি বাবদ সাচাংশা এত তারিখে পাই।
And then?
আমার হিসাব অনুযায়ী উপরোক্ত টাকা আমি কম পেয়েছি। মানে
Yes, very good.
amount has been not, my lord.
They will say the entire amount they have paid.
Kindly, my lord,
they will file a report on affidavit and they will say that the entire amount they have paid. What will this petitioner get?
But I asked, my lord, the widow.
এখানে আর কিছু করার নেই। Some amount has been deducted as overdrawn amount. They will affirm an affidavit saying that the entirety of the dues have been met.
Yes.
Madam, I'm paying for the petitioner. The Lordship, In this matter, your lordship, my grievance is that, your lordship, the petitioner retired from service on 31st of January 2023 as driver from Calcutta Street Transport Corporation, your lordship. And he has received an amount of rupees 9 lakh.
Wait, they are supposed to file a report on affidavit.
Lordship.
My lord, it appears for me, my lord, is a statement that, my lord, a substantial amount, my lord, is due and payable. Now, my lord, I do not want to, my lord, submit this statement because, my lord, it appears from the record that I have to submit a report. Lordship, kindly keep me, my lord, maximum 10 days time. I shall
I
file.
have given you.
My lord, I
direction.
know, my lord. I know, my lord, it's very embarrassing for me also, my lord, to seek any further time. But, my lord, so far, the statement which my lord handed over to my junior, my lord, by the accounts clerk, I myself, my lord, I'm not satisfied with it.
Ashun,
I shall file a report, my lord, whatever the payable.
Time to
we have
file
pay.
report on affidavit is
My lord, may I
extended
pray for kind indulgence, your lordship.
at
During
the prayer of.
pendency, your lordship, I have been paid rupees 1 lakh on 12th of July 2023. That is not on record, your lordship, because my lord has passed this order
That will be reflected in the
28th of
report.
June. Lordship.
At the prayer of Mr. Sen, learned additional government leader, appearing on behalf of Calcutta State Transport Corporation within bracket CSTC, bracket closed, full stop. Let such report on affidavit be filed by August 11, 2023, full stop.
11.
Exception, if any, by August 25, 2023, full stop. Next. It is submitted by Ms. Debasu, appearing on behalf of the petitioner, that during the pendency of the writ petition, a further sum of rupees 1 lakh, was paid in the bank account. Now, was transmitted to the bank account of the petitioner. Full stop. Let the matter appear at the next structure for further consideration under the same heading motion on August 30, 2020.
Get
I'm grateful.
30, Budbar.
আমাদের 11 তারিখের মধ্যে রিপোর্টটা দিতে হবে। এখানে থেকে 11 তারিখে
Yes, my lord, I am for the petitioner, my lord. This is a matter, my lord, relating to interest on ROPA 98.
Yes, on the microphone, please.
ROPA 98, my lord.
On the microphone.
Oh, ROPA 98, my lord.
Yes.
Your lordship passes several order, my lord.
Date of retirement
Date of retirement, my lord.
or is still in service?
Date of retirement, my lord, 2013, 31st October 2013.
এইখানে এইটা কোথায় গেল? আমার
এগুলো সঠিক টাকা।
কথাটা কোথায় গেল? এই খালি একটা জাজমেন্ট কেন? এটা আরেকটা আগের জাজমেন্টটা, ডিভিশন বেঞ্চের জাজমেন্টটা কোথায়? এই যে এই কথাটা আছে স্ট্যাটিউটরি কালার, এই কথাটা তো এই জাজমেন্টটা থেকে। আচ্ছা, এইটাতে এরকমই হবে। ওই যে আমাদের স্ট্যান্ডার্ড যেটা আছে ডিভিশন বেঞ্চের জাজমেন্টটা দিয়ে দেবে।
Lordship, I appear on behalf of the state.
How are you? You have not been keeping well, I heard.
Yes, my
Now
lord.
you're better?
I'm better.
All right.
My lord, similar matter.
You have to give, have you prepared a chart containing the dates of retirement?
No, my lord, I did not do
Why
this.
not?
This is the retirement of my lord, 31st January 2012.
31st January 2012, date of retirement. ওটা লিখে নিন আর ওই প্যারাগ্রাফটা একটু করুন। January 31, 2012. তাতে প্যারাগ্রাফটা হবে। Yes, you should have prepared a chart. Otherwise, it's very difficult for them. So many ROPA matters, so many gratuity matters. Why have you not prepared a chart?
I shall give.
Next time.
Similar, the date of retirement, 30th June 2012.
Ashun. June 30, 2012. Date of retirement. Only paragraph to her.
I am appearing on behalf of the client. I am led by promotion strategy. This is the matter pertaining to the gratuity and leave in cash. The petitioner was MD of respondent number 3. He is claiming representation and is at page 25.
Please give me your affidavit of service.
Lordship, my affidavit service is ready, but it has not been affirmed by.
Why not? The matter is going to appear today. All the respondents are here. You are appearing for?
For state, Milord.
For state. Then what happens to the respondent concerned? The answering respondent, number 3.
I have served.
You affirm the affidavit of service and come back. এটাকে পরের বুধবার রেখে দিই।
Death cum pension under death cum retirement benefit scheme 1990 was given retrospective effect.
Please speak on the microphone, sir.
The pension under death cum retirement benefit scheme was given retrospective effect from 1st April 1984. Those who are on the payroll on that day are entitled to get pension, provided they must exercise their option.
Yes.
I exercised my option now, but they did not release my pension. They have not, I exercised option. And I say, P2, your lordship, kindly come. Just a minute. This matter has been settled by Supreme Court, already
Similar matter, after my lord, the having been dismissed by the SLP by the Supreme Court, my lord, the other matters, my lord, came up before your lordship. Now, my lord, in those matters, now, my lord was kind enough, my lord, to grant me leave to file a report in the form of affidavit or affidavit. Now, my lord, kindly give me.
No. Was
As
the
CPF
petitioner
member,
is a retired
everything
employee
paid.
of Calcutta State Transport Corporation within bracket CSTC. Bracket closed, full stop. He was superannuated from service on May 31, 2020. Full stop. The petitioner's claim is that the petitioner exercised the option for payment of pensionary benefits under the Calcutta State Transport Corporation employees apostrophe service
Instruction nebo.
within bracket death hyphen cum hyphen retirement
Dispose of
benefits
admitted some
brackets
payment.
closed
আমি কি করবো?
regulations comma 1990 full stop. The said 1990 regulations
Madam,
were
may I leave
gazetted
lordship?
on was published in the Calcutta Gazette on April 22, 1991. Full stop. The said regulations came into force with effect from April 1, 1984. full stop. The benefits of the said regulations were available to the employees who were on the payroll of the corporation as on April 1, 1984. Full stop. Next. Mr. Ghosh, learned counsel appearing on behalf of the petitioner, submits that despite exercising his option within the stipulated time, the employer stroke CSTC has not paid the pensionary benefits of the petitioner till date. Full
One
stop.
more thing, Lord.
Such an action on the part of the respondent authorities is illegal and or arbitrary. Full stop. Next. Mr. Sen, learned additional government leader, submits that necessary instructions are required to be brought on record by way of filing of a report on affidavit, on the factual aspects of the matter. R capital A capital report on affidavit, report hyphen affidavit. Next. Considering the submissions of the parties and the materials placed on record, this court directs the respondent number 5 stroke managing director, CSTC or any other authority delegated by him to file a report on affidavit, R capital A capital, by August 18, 2023, full stop. Exception, if any, by September 1, 2023, full stop. Next. Let the matter appear for further consideration under the same heading, motion, bolded, on September 3, 2023. September 6, sorry. September 6,
September
2023. Yes.
May I get one more thing? I have to refund the contributory provision for now.
Achha,
And,
Mr. Ghosh,
and the excess gratuity, my lord, that was paid to me.
He also fairly submits that the petitioner is ready and willing to refund the excess gratuity amount and also
Employers
share of
provident fund.
contributory provident fund as and when directed by this court for release of pensionary benefits. Full stop.
Get for it.
This matter, Your Lordship, I am praying for 60% of my provident fund, which is due to be paid to the petitioner, Your Lordship.
There's a
Your
usual
Lordship,
order.
petitioner retired from service on 31st of August 2022 as feature from Calcutta State Transport Corporation.
I've seen the amount.
My lord, the only thing, my lord, it has been, my lord, subbed day before yesterday. So far, the amount which he claims that is due, that has not been, my lord, ascertained that due and right.
Then
Or my lord can dispose it of that whatever the actual dues.
the balance,
Or otherwise, I may come back with instruction, my lord.
because otherwise, again, there will be
Oh,
another,
yes.
another round of
Yes,
litigation.
yes. My lord, that is. Kindly pass an order, lordship. May I leave, lordship? Get.
আসুন, আপনি না এলে কি করে হবে? আপনাকে আমি ডাকছি হাতে হাতে। The petitioner worked as a helper. Now, the petitioner is a retired employee of Calcutta State Transport Corporation within bracket CSTC bracket closed full stop. The petitioner was superannuated from service on August 31, 2022. Full stop. Ms. Devasu, learned counsel appearing on behalf of the petitioner submits that the petitioner received a sum of rupees 11,72,000 as 40% of the provident fund dues on September 21, 2022. Within a month, 2022, within a month from the date of superannuation. Full stop. However, till date, 60% of the Provident Fund dues have not yet been disbursed to the petitioner. Full stop. Next. Mr. Sen, learned additional government leader, appears on behalf of CSTC and submits that necessary instructions are required to be taken in the matter with regard to the quantum of the Provident Fund dues yet to be disbursed to the petitioner. Full stop. Mr. Sen is permitted to take necessary instructions by the adjourned date of hearing. Full stop. Next. Let the matter appear for further consideration under the same heading motion bold on August 16, 2023.
I'm
Motion
grateful,
আর
Your
August 16 টাকে bold করে দাও।
Good.
235, my lord, I am for the petitioner. There is similar matter, my lord, is open 90.
What is the date of retirement?
Date of retirement, my lord, 30th June 2015.
Date of retirement? June 30, 2015. প্যারাটা করে দেবেন রাইডারটা।
Yes, my lord, this is a similar matter, my lord. Date of retirement, my lord, 31st March 2014.
March 31, 2014. 2014. প্যারাটা করে দেবেন। অন্য ম্যাটার।
Well, in this matter, I am for the petition. Well, this is my affidavit of service. Well, the petitioner before your lordship, Malad, was first appointed as a Malad the
Appearing, Mr. Prasad.
Yes, my lord.
You are the answering respondent.
My lord, I'm not the answering. I'm
Who is the
question.
answering
My
respondent?
lord, there is a college.
Techno India. Malad, Malad, in this respect, what happens, Malad, the gratuity amount of the petitioner,
Yes.
Malad, he has been served in the said college for more than 15 years, but it has not been paid. Only Malad release order has been given, but no gratuity amount. That is my claim before your lordship. Malad, your lordship kindly come to first your petitioner join in
One
the
second, please.
Institute of Computer Engineers, that is at page 18, annexure P2. Annexure P2 at page 18, your lordship kindly got it. Thereafter,
First, let me see what is the status with regard to the answering respondents.
yes, ma'am.
On 24th July, it is out for delivery. So now the answering respondent, what kind of a track report is this? It's out for delivery as far as the answering respondent is concerned. This is
Let me check.
এটাকে একটু
একবার
দিন না ওনাকে। Match it with the
Yes, yes.
record. The last one.
349769358. That is the regarding my lord, the probably University Grant Commission, UGC. And in respect of the others, the Techno University or the others, my lord, they have received the 349769327.
So
That is
your
the Chancellor.
answering respondent, as far as you are concerned, is respondent number 4.
Yes, my lord. They are the main respondent.
I am keeping it next Wednesday. Probably by that time they will
Grateful.
have it delivered. And
3 and 4, my lord.
are
They
the
are
main
the
respondents.
yes, ma'am. Because though the
They have to appear.
yes, my lord. Though they have, my lord,
To serve another notice, Ashwin. You serve just the notice, not the writ petition. You serve another notice. Despite service, no one appears on behalf of the respondents number 3 and 4. Full stop. Mr. Prasad represents the state of West Bengal. Full stop. Respondents number 3 and 4 are the answering respondents. Full stop. Let a notice of the writ petition be again served on respondents number 3 and 4, intimating that the matter will be taken up for further consideration under the same heading motion bolded on August 9, 2023. Server copy.
I'm good.
A proof of service shall be filed on the adjourned date of hearing. That was server copy.
yeah, but service to the
Lordship 2002. Lordship, I've got the petition also.
Yes.
Yes.
Lordship, the sum and substance of the matter is, Lordship, the petitioner retired from the service in the year 2017. But his retirement benefits was last paid on the year 2021, Lordship. I am seeking, Lordship, a late payment interest, Lordship, on the retirement benefits, Lordship. I am relying on, Lordship, pension payment on the page 20.
Page?
Lordship, page 20, Lordship. Kindly see page 20, Lordship.
Page 20?
Yes, Lordship. Pension payment order, Lordship. From 17, 18, 19, 20.
Pension payment order is not at page 20.
Lordship, from page 17.
17.
Yes, Lordship. Then, Lordship, at page 20, Lordship, that date of ending of service, 31st July
That
2017.
is all right.
And Lordship, I am also relying on page 26 and 27, Lordship, the bank statement, Lordship. The last payment of pensionary benefits is, Lordship, 22nd June 2021.
It's so difficult to. Is it possible to read?
Lordship,
What you have annexed on page 26?
Little not
Is it
legible.
possible to read the dates from there? You tell me. Yes, you are appearing for NBSTC.
No, we are for
What is the state?
We are
So who is appearing for North Bengal State Transport Corporation?
Lordship, one thing is, Lordship, my friend,
You give me your affidavit to serve.
Lordship, my friend failed to serve the other respondents. Only the
Then
GPS.
why are you placing on matter today without serving? The main answering respondent is NBSTC.
Yes, Lordship. I've tendered my apology. Lordship. My friend failed to serve on time, Lordship. Lordship, kindly give me 7 days, Lordship.
16th August.
Lordship.
My lord, I appear for the ECL, my lord. That matter, my lord, your lordship knows, remembers. He's a reply. I have nothing to say now.
You have made your submission.
Yes, I have nothing
You
to
have
say, my lord.
completed.
Yes, he's on reply, and suppose he is to submit a written notes of
Your
argument.
lordship asked me to file a written notes of arguments. I have prepared it. And very short reply, my lord. My learned friend essentially argued on 2 points that I have not challenged the circular.
Yes.
My submission to that extent is that I need not challenge the circular because the circular is in aid of
In your favor.
yes, is in aid of the writ petitioner.
And that is your case in the writ petition also.
And the second point, my lord, it has been urged, my lord, that FR 22 and 23 is not applicable to the writ petitioner, and they are not the government employees. So government employees and public sector. Now, so far as FR 22 and 23 is concerned, my lord, that is in the circular itself, my lord. The circular was issued, my lord, in the line of FR 22 and 23.
It says the languages, it is embedded.
Yes. And so far as the conditions of service of PSU and government sector is concerned, my lord, it is completely, my lord, misplaced, my lord. It is not the issue in the writ petition. Now, my lord, the 3 judgments, my lord, which has been cited by my learned friend, my lord.
You can quickly distinguish them.
Lordship. Now, AIR 1970. My lord has got it, my lord. AIR 1970, Supreme Court 1150. My lord, this is, my lord, here the issue is, my lord, the applicability of Article 311 in respect of a public sector undertaking. Here it was held, my lord, that it is not applicable because it's not a civil post. And government employees, for the government employees, 311, what does 311 says, my lord? It deals with, if your lordship sees paragraph 6 at the bottom, 311 is essentially paragraph 6 of the said judgment. At the bottom portion, my lord, 311 essentially pertains to dismissal, removal, or reduction in the rank of persons employed in civil capacities under the union or state. Well, it is absolutely not relevant in this case. And here it was held. My lord, the other judgment, my lord, AIR 1967.
What he was saying was that if you look at the last paragraph, that it is not a department of the government.
Lordship.
An autonomous body is not a department of the government.
government.
That is what he was.
And that is not the issue in the writ petition also. I am not saying that. Now, my lord, the other judgment, my lord, AIR 1967 is SC 948. My lord, here also, my lord,
AIR?
1967 Supreme Court
Yes.
948.
Yes, yes.
My lord, here also, my lord, the issue was, my lord, the wage structure of the public sector undertakings versus the private sector. They cannot be same. My lord, this is also misplaced. My lord, if your lordship sees the opening line of the
The
judgment.
issue was whether the wage structure of public sector undertaking should be similar to the government employees, not with the private sector undertakings. Should be similar to the government.
Should be similar.
So paragraph 21 he relied upon.
Paragraph 20, my lord, the
21.
issue, my lord, that is also, my lord, this deviating from the issue in this writ petition. That is my humble submission. My lord, paragraph 21 says not the service conditions of the employees in public sector undertakings are analogous to those of the government employees. My lord, there is no security of service. The fundamental rules, this was, my lord, this is the point where it was hard, my lord. The fundamental rules do not apply to them. Now, my lord, my case is not that, my lord, I am asking for the fundamental applicability of fundamental rules out of nothing. My case is
because they have embedded it in their
for removal of lordship. For removal of anomaly, they have issued the circulars. Now it has been interpreted in a way which is not conducive. Now the other judgment, my lord, that is also, my lord, similar. That is, my lord, unreported decision, Kamal Kumar Kalia versus Union of India, Delhi High Court.
Yes.
My lord, that is also, my lord, the issue is treatment of public sector employees that cannot be at par with the government employees. Paragraph 7, my lord, my learned friend relied upon. The writ petitioner is not asking for, my lord, the similar treatment of himself as that of a government servant. That is not the issue at all. That is my humble submission. So these judgments are not applicable in this case. Your lordship, but on the last occasion, I could not, what I could understand, your lordship was asking for some kind of authorities possibly, my lord, regarding the applicability of the circulars and the statutes, my lord, versus the statutes, something like that. My lord, I have
Statutory rules and regulations versus the applicability of
I
the
my lord, I do not
circulars in
know
administrative law.
how far your lordship will be. What are going? No, no, my lord, I have just a very small decision. Yeah, my lord, this is paragraph 6, my lord. May I read out paragraph 6 of the said judgment, my lord, 2008, volume 14, SCC 336. Paragraph 6, my lord, may I read out, my lord, the issue relating to effectiveness of a circular contrary to a notification statutorily issued has been examined by this court in several cases. A circular cannot take away the effect of notifications statutorily issued. In fact, in certain cases, it has been held that the circular cannot whittle down the exemption notification and restrict the scope of the exemption notification or heat it down. In other words, it was held that by issuing a circular, a new condition thereby restricting the scope of the exemption or restricting or whittling it down cannot be imposed. The principle is applicable to the instant cases also, though the controversy is of different nature. Our controversy is also of a different nature. My lord, this matter relates to central excise. Now, my lord, my lord, the issue, my lord, is that, my lord, the circular has been framed, my lord, in the line of FR 22 and 23. Now it cannot whittle down the principles of FR 22 and 23 in their own way. The circular is in, my lord, is on the basis of the notification of the rules of FR 22 and 23. This much, my lord,
the impugned order proceeds on the basis that FR 22 and 23 need not be taken into account because it is the fundamental rules have been issued prior to the circular.
Right.
That is the decision-making process of the
Lordship.
authority concerned.
And moreover, my lord, there is another aspect, my lord, I
before start by learned friend, and I am raising a objection because at this stage, at the time of final hearing, my learned friend client raised an mental limited problem. The reference was made in 1998. They did.
All right, I will have to decide. Let
As a-
him,
as a-
let him complete his submission. I have to decide.
That has been taken, my lord, in affidavit in opposition also. Opposition, in reply.
Your writ petition.
In my writ petition, my lord, in my writ petition, generally he appears for, and in reply also.
Tested the matter. Very well,
My lord.
let them.
My
Did you
lord,
take that point of maintainability before the tribunal?
No, that.
my lord,
Please, I am asking
I'm-
him. Why?
Extremely sorry.
Did you take that point
yes, my lord.
before the tribunal?
Yes, my lord.
All
That question also raised before in the award, before the tribunal also.
All right, you show me that.
Yes, ma'am.
Yes,
I will-
now you want to draw the attention to section 7.
My lord. First of all, my lord, section 7A of the Industrial Dispute Act, my lord. My lord.
অমিতাভ বন্ধ করে দিতে বলবে।
My lord. Tribunal, my lord.
Yes.
The appropriate government may by notification in the official gazette constitute one or more industrial tribunal for the adjudication of industrial disputes relating to any matter, whether specified in the second schedule or third schedule, and for performing such other functions as may be assigned to them under this act, my lord. In terms to section 7A, my lord, if my lord come to section 10, my lord, that is the procedure prescribed. Section 10, my lord, reference of a dispute to board, courts or tribunals, my lord. My lord, where the appropriate government is of opinion that any industrial dispute exists or is apprehended, it may at any time by order in writing, my lord, clause D, refer the dispute or any matter appearing to be connected with or relevant to the dispute, whether it relates to any matter specified in the second schedule or third schedule, to the industrial tribunal for adjudication, my lord. Now, my lord, at the third schedule, my lord. Second schedule, I will place the second schedule and third schedule also, my lord, of the Industrial Dispute Act, my lord. So, my lord, in the second schedule, my lord will have a look that second schedule is relates to section 7, my lord. Section 7, my lord, is a reference to the dispute to the labor courts. Section 7 of the Act, my lord, that is the reference.
Yes.
Section 7, my lord, that is the labor code. And my lord, third schedule is with respect to section 7A, that is reference of dispute to the industrial tribunal, my lord. Here, my lord, reference has been made to the industrial tribunal, my lord. Now, my lord, the third schedules specified the items or the terms which can be referred to the industrial tribunal for adjudication, my lord. That is, my lord, wages, including the period and mode of payment, compensatory and other allowances, hour of work and rest intervals, leave with wages and holidays, bonus, profit sharing, provident fund and gratuity, shift working otherwise than in accordance with the standing orders, classification by grades, rules of discipline, rationalization, retrenchment of workmen and closure of establishment, and any other matter that may be prescribed, my lord. Now, my lord, what has been referred, my lord, at page 29, my lord, of my writ application? My lord, reference was drawn, my lord, that schedule, my lord, below, whether the management of the Bhujudi coal washery of Messrs. Bharat Coking Coal Limited is justified in not departmentalizing the contract workers as shown in annexure employed in the job of maintenance of water supply system at intake well at Bhujudi coal washery. The question referred of departmentalizing or non-departmentalizing of the contract labor, my lord. My lord, the legislatures, my lord, intentionally, my lord, puts this question out of the purview of the third schedule, my lord. My lord, if my lord comes to the second schedule, my lord, second schedule, item number 2, my lord, that item number 2, which can be referred to the labor court, my lord, that is an application and interpretation of standing order. My lord, my lord, the matter, my lord, relates to absorption of contractual labor, my lord, and whether their job is perennial nature or not, my lord. My lord, in this field, my lord, the Contract Labor Regulation and Abolition Act, my lord,
আছে এখানে
my lord, Contract Labor Regulation and Abolition Act, my lord.
এখানে ছিল কোথায় গেল অমিতাভ গেল কোথায় you have another copy
I don't have.
এখানে আছে
আছে
যাই হোক দিয়ে ওনার আরেকটা কপি থাকলে তো আগের দিনই আনাতে বলেছিলেন দুটো ইন্ডাস্ট্রিয়াল ডিসপিউট হ্যাঁ ওই যদি তারপরেরটা
My lord, my marking was there.
That's yes, all right.
My lord, the prohibition of the contract labor, my lord, if my lord, the central government, my lord, by notification, my lord, have to made a declaration as to the prohibition of the contract labor, my lord. My lord, before that, for the purpose of that declaration, my lord, the central government, my lord, the my lord, labor or the had to apply it before the appropriate government, my lord, whether it is central government or the state government, for and raise the dispute with respect to the absorption of the contract labor, and after determining that whether the job is perennial nature or not, the appropriate government by notification will decide that the absorption is of contract labor is necessary or not, my lord. And my lord, if my lord come to the last paragraph, my lord, the decision of the appropriate government is final, my lord. My lord, section 10 is itself a code inside the statute, my lord. It prescribes the complete procedure, my lord, how the contract labor has to get into absorption category, whether considering the fact that whether the job is perennial nature or not, my lord. My lord, in this matter, my lord, the respondents never approached before the appropriate government for any declaration or issuing of any notification to that effect, my lord. My lord, second schedule deals with the standing order. If the appropriate government prescribes a notification, my lord, that standing order can be challenged before the lower court under the second schedule of the Industrial Dispute Act, my lord. Unless and until that notification or that declaration has been issued by the central government, my lord, now the industrial tribunal has no jurisdiction to enter into the dispute involved in it, my lord.
Yes.
My lord, my question raised before by my lord that whether I raise the issue before the tribunal, my lord.
So under section 10D, why can it not refer it to the tribunal?
My lord.
Under section 10D of the Industrial Disputes Act,
My lord.
why can this dispute not be referred to the tribunal?
My lord, 7A, my lord, role of industrial tribunal.
No, first look at 10D of the Industrial Disputes Act.
My lord. My lord, 10D of the Industrial Dispute Act, my lord.
Yes.
Specified, my lord, the dispute which, my lord.
Yes.
Refer the dispute or any matter appearing to be connected with or relevant to the dispute, whether it relates to any matter specified in the second schedule or third schedule to the tribunal for adjudication. My lord, this dispute is not under the second schedule, nor third schedule, my lord.
Why?
My lord, I put
Just
up
now you referred to the second schedule.
my lord, second schedule, my lord, second schedule has to be, my lord, had the dispute be referred to the appropriate government under section 10 of the Contract Labor Abolition Act, and had the appropriate government issued that notification, my lord, then the referred would be then that notification or that standing order, that dispute has not been referred under section 10 to the appropriate government, my lord.
Discharge or dismissal of workmen, including reinstatement.
My lord,
second schedule 3.
My lord, they are not workmen. They are not been discharged, my lord. They are claiming absorption, my lord, on the ground of the job is perennial in nature.
Yes, because they are not being.
They are not being discharged, my lord. They are not into the role.
Discharged.
My lord,
that is why they are claiming.
My lord, they are not under.
All right, I have understood that point. Now, please proceed on the merits.
My lord, my submission, my lord. Section 10 is the section 10 of the my lord, Contract Labor Abolition Act.
Yes.
My lord, is the code, my lord.
Yes.
My lord, the respondent had to approach before the appropriate government under section 10, and unless and until that notification is being issued by the appropriate government, my lord, this honorable court under Article 226, my lord, cannot take up the issue.
The issue has been approached. That is why the central government has directed the issue to be decided by the tribunal.
No, my lord, that has not been approached under section 10 of the Industrial
all right,
on the Contract Labor Abolition Act.
On the merits. Because the central government clearly refers the said dispute for adjudication. Because without approaching, how can the central government refer the dispute for adjudication by the Central Government Industrial Tribunal?
My lord,
page 29 clearly stipulates. Anyway, no point in getting into the technicalities because some dispute, the central government has been approached and the central government has referred it to the industrial tribunal. Now, next.
My lord, on the last occasion, my lord, I submitted that the Supreme Court cases, my lord.
No, first you take me to the award.
My lord.
You have to show me what are the infirmities, and in judicial review, how can I get into that?
My lord. Now, my lord, at page 61, my lord.
Yes.
My lord, reference, my lord, that as to whether the management of the Bhujudi coal washery of Bharat Coking Coal Limited is justified in not departmentalizing the.
You have read the dispute already.
My lord, that dispute, my lord.
So 3 issues have been framed at page 63.
My lord. My lord, whether.
Then take me to the findings of the tribunal.
Issues, my lord, whether the working of the workmen under the different categories of the BCCL be considered as employer-employee relationship, whether the workmen have been working against the permanent or temporary nature of the job, and whether the workmen are entitled to be regularized in service. That is the 3 issues, my lord. My lord, if my lord,
yes.
Thereafter, my lord, as indicated, there is no dispute that the contract under whom the workmen have been working are contractors of BCCL. Therefore, my lord, the workmen are working under the contractor of BCCL, not under the role of the BCCL, my lord. They are not the employees.
That I have to
My
see
lord.
now. You please read.
And that same set of workers, which include the referred workmen, have been continuously working in the same job and at the same place since the year 1983.
Yes.
The documents relied on by the union as the gate pass, payment sheets, attendance registers. From the very pleading of the management also, and from the evidence of the witness of the management, namely Murali Prasad, it is found that the job of uninterrupted water supply to the plant is a permanent nature of work, and there are permanent employees engaged in the work. The management consistent stand is that the workmen in question were not engaged against the permanent job, but against the temporary job in the summer season only, and sometimes are engaged temporarily for draining water through the Kacha channel and in the maintenance of pump, etc. The oral evidence of PW1 goes to show that the workmen engaged in the supply of water to the plant for production of goods to the benefit of the management. Supply of water is absolutely required for working of the washery as well as for the drinking purpose. Evidence of the witness for the union on this code remained unchallenged. In view of the above, there is no persistence of doubt about the permanent nature of the work in which the referred workmen have engaged. But the question certainly deserves consideration as to whether the workmen are entitled to be considered as the employee of the BCCL, even in that version of the management is taken for granted. That there are other permanent workers in the said work and additional work are not required. The reported decision of the Apex Court in the Steel Authority of India Limited may be seen. It has been held that such cases where the contract is required to discharge statutory liability of the principal employer stand on a different footing and not possible to deduce from them the broad principle of law that on the contract labor system being abolished under subsection 1 of section 10 of the Act, the contract labor working in the establishment of the principal employer has to be absorbed as regular employees of the establishment. My lord, that is not the subject of judgment, my lord. I will place, my lord. The management has not satisfactory proof by sort of evidence that the
By any
workman-
sort of evidence.
by any sort of my lord, evidence that the workmen have been engaged as contract labor during the month of April and May each year. On the other hand, the gate pass, payment, register, etc. are ample evidence to find to the contrary. The management has failed to prove that the work are prohibited under the Contract Labor Abolition Act, or at all the contractors have been issued with the license under the said act to consider the workmen as contract laborers under them. There is thus reason to believe that the real facts are being camouflaged. There is a clear admission by MW1 that the workmen have been engaged in the supply of water to the plant for production of goods for the benefit of the establishment. The case of the workmen thus stand passed successfully the acid test laid down by the Supreme Court in the case of HON'BLE versus Allah.
Case of HON'BLE, wherein it is held.
My lord. Wherein it has been held that the true test may, with brevity, be indicated once again. Where a worker or a group of work laborers to produce goods or services, and these goods or services are for the business of another, that other is in fact the employer. He has economic control over the workers' substance, skill, and continued employment. It be for any reason jobs of the worker is virtually laid off, the presence of intermediate contractors with whom alone the workers have immediate or direct relationship in contract is of consequence, when on lifting the veil or looking at the conspectus of tutors governing employment, discern the naked truth, though dropped in different perfect paper arrangement, that the real employer is in management. Some other decisions of the Honorable Supreme Court, including that of the Steel Authority of India Limited, have been relied on in support of the above legal proposition. There is no doubt that the facts and circumstances of this case are different, distinguishable from that of the Limedas case, or LAB, denying the regularization. Hence, the ruling is not applicable to this case, as the status of the workmen in this case is not that of illegally appointed workers. In the above circumstances, it has simply been concluded that the action of the management of Bhujuti Coal Washery of BCCL is in not departmentalizing the 16 workmen employed in the job of maintenance of water supply at the intake well of the Bhujuti Coal Washery is not legal and justified. The workmen are entitled to be departmentalized in appropriate grade in grade 1 of the management, and therefore pass the order accordingly, my lord. My lord, in the award itself, my lord, kindly take into consideration that the industrial adjudicator took the trouble in his shoulder to decide that the job is perennial in nature.
He has to.
My lord, the section 10 of the Contract Labor Abolition Act, my lord, speaks of otherwise, my lord. Section 10 of the Contract Labor Abolition Act, my lord, says that it is the appropriate government will decide that the job is perennial nature or not, and they have to be absorbed as contract labor or not. And without the decision of the appropriate government, my lord, the industrial adjudicator cannot, my lord, decide.
The government has referred the dispute to the industrial adjudicator.
My lord, on that score, my lord, I will submit my judgment, my lord.
Yes,
my lord.
Please do.
Second, my lord, the decision of the industrial tribunal, my lord, the decision of the industrial tribunal, my lord, though, my lord, consider that the contractor that the respondents are not the employees of the BCCL, my lord. And it is also recorded, my lord, that the respondents are working for only summer period. That is the 2 months.
Where?
My lord. My lord, that has been relied
It
on.
has been said that the management has not been able to prove
That has been relied, my lord. That has been relied, my lord, and that has not been disputed in the award, my lord.
Yes, the award clearly holds that it is the management has not been able to prove that only for 2
Management,
months.
my lord.
Yes.
Management is not able to prove, my lord, that in his oral evidence that the work is perennial, the work is not perennial in nature. My lord,
And
but the
also that
tribunal, my lord,
the tribunal clearly holds that the gate passes and the salary slips prove to the contrary. And anyway, it is a statement, it is a holding of fact. It is a holding of fact after an analysis of evidence.
my lord.
So in judicial review, how can you expect the court to get into that? Tribunal clearly holds that it is found that the job of uninterrupted water supply to the plant is permanent in nature.
My lord, my submission, my lord, with respect to the, my lord, the provisions, my lord, of the
So
contract
one
labor.
thing is on the maintainability.
My lord.
That
That
is
is,
one.
that
And
industrial
second thing
tribunal.
is on the analysis of the evidence.
My
And
lord.
what else?
And my lord, since the industrial tribunal is not authorized, my lord, by law to take up the responsibility of the appropriate government and to decide the question as to the absorption, my lord, this honorable court also, my lord, has no, but with regard to the disputed questions of fact involved, my lord, under Article 226, my lord, this honorable court, without being specified by the, without being approached under Section 10 of the Contract Labor Abolition, my lord, this honorable court also may not delve into the disputed questions of law, my lord. That is my respectful submission.
Disputed questions of law.
Disputed questions of fact, my lord. That is my respectful submission in terms to the.
That I have not been able to understand. Finding of facts have been made by the tribunal. Finding of facts have been made by the tribunal. This court is telling you that this court in judicial review cannot go into the findings of fact.
My lord.
The tribunal has assessed the evidence and come to a finding.
What
are you submitting?
My lord, my respectful submission is that under the Contract Labor Abolition Act, my lord, the fact-finding authority is the appropriate government, my lord, not the industrial tribunal, my lord. That is my respectful submission, my lord. And that is the Section 10 of the Contract Labor Abolition Act, my lord. My lord, that is my only submission, my lord. And with that respect, my lord, may I be permitted to place judgment, my lords?
Yes.
My lord. My lord,
You have handed over your notes already?
My lord, Steel Authority of India Limited, my lord, that is 2001. 2001 7 SCC, my lord, page 1.
Yes.
Page 1. My lord, before the Steel Authority of India judgment, my lord, if my lord come to page 120, paragraph 125, my lord, of the report, my lord. That is the upshot of the discussions outlined, my lord. Para 125, my lord.
Yes.
My lord.
Yes.
we come to at page 62, my lord, that is the next page. Paragraph 2A, my lord. A notification under section 10 subsection 1 of the CLRA, Contract Labor Abolition Act, prohibiting employment of the contract labor in any process, operation or other work in any establishment has to be issued by the appropriate government after consulting with the Central Advisory Board or the State Advisory Board, as the case may be, having regard to the condition of work and benefit provided for the contract labor in the establishments in questions and other relevant factors, including those mentioned in subsection 2 of section 10. In as much as the impugn my lord, thereafter, my lord, point 5 below at page 60, running page 63 below. Five, my lord, running page 63, next page below.
Yes.
On issuance of prohibition notification under section 10 subsection 1 of the CLRA Act, prohibiting employment of contract labor or otherwise in an industrial dispute brought before it by any contract labor in regard to the conditions of service, the industrial adjudicator will have to consider the question whether the contract has been whether the contractor has been interposed either on the ground of having undertaken to produce any given result for the establishment or for supply of contract labor for the work of establishment under a genuine contract, or is a mere muse or camouflage to evade the compliance with various beneficial legislations so as to deprive the workers of the benefit thereunder. If the contract is found not genuine but a mere camouflage, the so-called contract labor will have to be treated as employees of the principal employer, who shall be directed to regularize the service of the contract labor in establishment concerned, subject to the conditions as may be specified by it for that purpose in the light of para 6 hereunder. Point 6. If the contract is found to be genuine and prohibition notification under section 10 subsection 1 of the CLRA Act in respect of the establishment concerned has been issued by the appropriate government, prohibiting employment of contract labor in any process, the operation or other work or any establishment, and where in such process, operation or other work or the establishment, the principal employer intends to employ regular workmen, he shall give preference to the erstwhile contract labor if otherwise found suitable, and if necessary by relaxing the conditions as to the maximum age appropriately, taking into consideration the age of the workers at the time of their initial employment by the contractor, and also relaxing the conditions of the academic qualifications. 126, my lord, para. We have used the expression industrial adjudicator by design as determination of the question aforementioned requires inquiry into disputed questions of fact, which cannot conveniently made by the High Court in exercise of the jurisdiction under Article 226. Therefore, in cases, the appropriate authority go into those issues will be the industrial tribunal court, whose determination will be amenable to judicial review.
So why are you citing this? I cannot
My
understand.
lord, unless and until the prohibition notification has been issued, my lord, the industrial adjudicator, that is the industrial tribunal, cannot go. The industrial tribunal, my lord,
saying that the prohibition notification
has not been issued.
It is saying that if it is issued, then the next step is before the industrial tribunal. Where does it say that without being issued, the industrial adjudicator cannot go into the facts? Where does it say in the statute?
My lord, 6.6, my lord, 0.5 and 0.6, my lord.
Yes.
On
if it
issuance
is
of
issued- If it is issued,
my lord,
where is the case where it is not issued discussed over here?
my lord, kindly, my lord, section 10 of the act itself.
I have seen that. I have seen that.
My lord, without issuance, my lord, আরেকটা judgment দিও তো, ওটা vigor list টা দাও তো। My lord, may I be permitted to place? 1971 two Supreme Court cases, my lord.
Yes.
724, my lord. That has been taken into consideration in this case. That is the Vegolis case, my lord. Age হচ্ছে 724. My lord. If my lord come to paragraph 43, my lord, 43 of the report. What three, my lord?
Yes. In so many establishments, regularization is not considered.
My lord, regularization, my lord, is simpliciter, not regularization, my lord.
Has it been referred under section 10 over here?
This matter, my lord, has not been referred under
Section 10. Then why are you going into that?
They has to refer the dispute to under section 10, my lord. My lord, kindly paragraph 43, my lord. We are emphasizing the provision of section 10 to highlight the point that a particular authority acting in a particular manner has been given the power and jurisdiction to decide whether contract labor has to be prohibited in any establishment. Before such a decision is taken, the representative of the workman, contractor, and the industry has an opportunity to express their opinion. Before such a decision is taken, the representative of the workman, contractor, and the industry has an opportunity to express their opinion. The more important aspect to be noted is the provision in the explanation which makes the decision of the appropriate government final on the question whether any process or operation or work is of perennial nature. We have already extracted the whole of section 10, and one of the relevant factor is that contained in clause B of subsection 2, in respect of which the explanation makes the decision of the appropriate government final. The appropriate government, when taking decision under section 10, will have an overall picture of the industries carrying on similar activities and decide whether contract labor is to be abolished in respect of the activities of that industry. Therefore, it is reasonable to conclude that the jurisdiction to decide about the abolition of contract labor, or to put it differently, to prohibit the employment of the contract labor, is now to be done in accordance with section 10. Therefore, it is proper that the question whether the contract labor regarding the loading or unloading in the industry of the appellant is to be abolished or not is left to be dealt with by the appropriate government under the Act, if it becomes necessary. On this ground, we are of the opinion that the discretion of the industrial tribunal in this regard will have to be set aside. My lord, here, my lord, industrial tribunal has exercised discretion, my lord. industrial tribunal suo motu take on its own shoulder whether the contract labors are prohibited or not, whether the job is under the prohibited category or not, whether the job is perennial nature or not, everything without the decision of the appropriate government, my lord. The industrial tribunal has no jurisdiction, my lord. That is my respectful submission. Has no jurisdiction to decide suo motu. If not, a notification or a declaration has been issued by the appropriate government. It is the jurisdiction of the appropriate government to decide whether the contract labors is to be abolished or not. And if the appropriate government has decided in favor of the contract labor and still
The question is not under section 10. The question is whether the employer committed in any infirmity in not, they have used the word departmentalizing. The question is in not absorbing the labor. That is the short
lord,
question that has been referred.
my lord, my respectful submission, my lord.
In order to come to this decision, the industrial tribunal has considered certain factors. Just because some of those factors are similar to the factors of section 10, you cannot say that it has considered section 10 and without considering the provisions of section 10, this could not have been arrived at.
My lord, my respectful submission is that, my lord, the contract laborers are not the employees of the BCCL.
Yes.
My lord, they are the contract
That is
laborers.
why you have discharged them.
My lord,
the question,
it is
you have
not
refused to not discharge them, you have refused to absorb them. The government has referred a particular dispute, whether you should have absorbed them or should not have absorbed them.
My lord, it is not their case even, my lord. They are the employees of BCCL. It is their case, my lord. They are
That
working.
you should have absorbed them. There are cases that you should have absorbed them.
My lord, they are the employees of a contractor, my lord.
That I have understood.
My lord. My lord, it is and there is no employer-employee relationship between the employer and the, my lord, respondents, my lord. My lord, that is my respectful submission, my lord.
Yes. Yes.
My lord.
Yes.
Well, may I submit?
Yes.
First of all, my learned friends.
Please speak on the microphone.
First of all, my learned friends client raised an objection that the industrial tribunal has no authority to decide this issue.
Yes. Because it is not a prohibited establishment under section 10.
Yes. Now, my lord, kindly see, my lord. Even, my lord, they did not raise any objection before the industrial tribunal.
Yes, they have. Page 63.
Well, very well, my lord. But now they have, at this stage, they cannot.
They have raised this objection at page 63. You have to answer that.
Well, before that, my lord, your lordship, kindly see page 29. Kindly see the page 29. Regarding the reference.
Yes, he has drawn this court's attention. I have read that.
Yes. So this was the reference made by the government before the industrial tribunal to
on the issue of absorption.
Issue of absorption. My question is also the issue of absorption. We are since 1983 till date, we are working in the said colliery. Some of them has already died. Now at this stage, my lord,
Now you have to answer the issue raised at page 63 top.
page 63 top.
He is trying to contend that if the government has not prohibited the establishment from getting the work done through contract labor, how can section 10 of the Contract Labor Abolition Act come into play? That is what he is submitting.
On page 60, that is about middle portion of the paragraph.
Please see what the management's argument is. At the top.
I'm reading. I'm reading. I'm reading.
At the top, they are temporarily.
They are the temporary engaged for annual maintenance of the pump and well, and that said temporary job have not been prohibited by the government under the Contract Labor Abolition and Regulation Act, challenging the maintainability of the reference. The various grounds like jurisdiction, absence of employer-employee relation, the employer asks for an award, justifying their action in not departmentalizing the service of the workman as legal and entitling them to be no relief. Now, my lord, perhaps it was Contract Labor Abolition Regulation Act comes with it. But we are working them. They did not discover.
Perhaps, what did you say? Perhaps.
My submission before your lordship is this, that we are working since 1983. They did not disturb my working. My prayer, our prayer was to regularize my appointment.
Now they have to see whether this regularization, this issue has been referred to the industrial tribunal and what are the factors that has been taken. How has the industrial tribunal addressed this issue?
Now, our next paragraph. On a careful perusal of the pleadings of the parties' documents, relied on the evidence adduced, it appears that there is no dispute relating to the fact that there is no direct relationship of the parties as employer-employee, as admittedly the workmen work under different contractors. That's correct, ma'am. That's correct.
The industrial tribunal, where has it found on the issue of jurisdiction? It has gone into the issue of evidence and facts. First is the issue of jurisdiction.
Yes.
Where has it answered?
Well, that is the issue framed here. 3 issues were framed.
That is on the facts. Where is the issue with regard to jurisdiction been answered?
Well, regarding the jurisdiction, my lord, next paragraph, my lord, as indicated, but there are 3 issues on this page. As indicated above, there is no dispute that the contractor under whom the workmen have been working are the contract of BCCL. Well, that is the findings of the.
That is enough without answering the issue of jurisdiction.
Well, this is clear, my lord, that this line is also clear. That as indicated above, there is no dispute that contractor under whom the workmen have been working are the contracts of the BCCL, contractors of BCCL. So therefore, they are under the employees of the BCCL. This is my humble submission.
Yes, you submit.
Now, my lord, the industrial tribunal elaborately discuss everything.
With regard to the evidence and facts.
With regard to the evidence and facts. According to evidence and facts, they have passed this award. And since your lordship kindly consider this thing, that since 1980.
You have to come back prepared on the issue raised by him, which appears at the top of page 63. I'm keeping it next Wednesday. Please come back prepared on this.
Very well.
His issue is very clear.
Yes. No.
His issue is without being a prohibited establishment under Section 10 of the Contract Labor Regulation and Abolition Act, the Industrial Tribunal lacked the jurisdiction to enter into that issue. That is his issue. I will record that. Please come back prepared to submit on the next day. Ashu.
My lord, instead of next Wednesday, my lord, 9th, my lord.
Well, 9th, I have some personal difficulties there. I will have to check.
The problem is that I have now started listening to it.
For medical checkup.
Next Wednesday, you have a problem,
My lord,
personal problem.
Personal problem.
All right, then 16th.
My lord.
Below on 16. Ready.
Mr. Raichaudhuri, learned counsel appearing on behalf of the petitioner, draws the attention of this court to the point of reference made at page 29 of the writ petition. Full stop. He submits that the issue that was referred related to absorption stroke departmentalization of 16 contract workers working at Bhojudi Coal Washery under Bharat Coking Coal Limited. Full stop. While adjudicating the issue under reference, the industrial adjudicator did not answer the issue that was raised in respect of jurisdiction by the management. Full stop. Under the Contract Labor within bracket Abolition and Regulation bracket closed Act, first the government concerned had to declare an establishment a establishment, a prohibited establishment. Full stop. The appropriate government, after consultation with the central board or the state board, had to prohibit the employment of a contract labor in any process, operation or other work of the establishment before the industrial adjudicator could decide the issues enumerated in Section 10 within bracket 2 of the 1970 Act. Full stop. Next. Now, in the present case, the establishment was not a prohibited one under Section 10 within bracket 1. Full stop. 1 of the 1970 Act. Full stop. Therefore, the industrial adjudicator could not go into the issues in relation to Section 10 within bracket 2 of the 1970 Act. Full stop. Therefore, the industrial adjudicator acted without jurisdiction. Full stop. Next. Mr. Chatterjee, learned counsel appearing on behalf of the respondent number 3 is permitted to make necessary submissions with regard to the issue that even without being described as a prohibited establishment under section 10(1), the issue of absorption stroke departmentalization of the contract laborers would be adjudicated upon by the industrial adjudicator. Full stop. Next. Let the matter appear for further consideration under the same heading for orders bolded on August 16, 2023. Full stop. প্রথমে written instructions submitted on behalf of BCCL cost title
প্রথম টাইপ
My lord, the written notes of argument, I'm sick, my lord, the written notes of argument has been made by him. It's all right. Now, if he wants, my lord, the other side has given some case laws.
Mr. Chattopadhyay was permitted to take some instructions on the last occasion.
Yes, my lord, I have explained it in the notes, my lord. I've explained it in the notes, but if I can explain also. If your lordship, my lord, learned friend is saying that please. My learned friend is saying.
No, my lord, now the law has changed to such an extent
It's not a file, but
that, no, it's all right.
Actual
I'm just
file,
on the academic issue, my lord. That even if a person has worked for 40 years
but it has covered, my lord.
or 20 years, whatever it may be, he does not get the right of appointment because it must be in accordance with the statute. One cannot go beyond the statute. And if somebody relies on the statute, it has been an open interview. It must be open. It must be open to all. It's not that one man. I consider that. I'm just academic discussion.
No, Mr. Chatterjee has relied on various judgments. So those
But the
judgments
point
are
is
after
this-
taking into consideration section 10 of
But
the
my lord, the point is this: whether a workman, he has to be a workman, or workman means of that company. Anybody outsider cannot under the
that is
Industrial
very
Disputes Act.
but the division bench judgment is could have been distinguished by you. The division bench judgment relied upon by Mr. Chatterjee.
Beneficial piece of
Yes,
Of this High Court.
Should be made to sharp.
That is quite similar to the facts of our case.
My lord, earlier the Supreme Court, whatever it may be, my lord, on the
This is
plight
very
of
recent judgment, 2019 judgment.
5 to LLL.
2019 SCC Cal 4953.
4156. Your lordship has been pleased to instruct me, take instructions with regard to point that I have taken. Well, with regard, the question is this, his judgment I have not dealt with yet. But factual aspect, I am ready. I have prepared in the note. I can explain. I was fell ill for the 15 days. A viral fever. Only.
So today you are seeking an
today, my lord,
accommodation.
Today, my lord, the position is this: I can satisfy your lordship the factual position that it is not a perennial nature of job. There is no evidence. The evidence
No,
is
that you do
insufficient.
not have to satisfy. I have, because on the question of facts, I will not be able to reopen in judicial review. What I wanted to know is that on which documents did your witness rely upon before giving the evidence? That is the limited point on which I asked you to take
there
instructions.
are two documents. One is judgment of the single bench judgment and division bench judgment, which have been referred in the written statement. I have mentioned there in my notes. That judgment clarifies everything. Even in a similar case, another union claiming to be the worker of the Tarapata Ghosh, he asked for absorption. His case has been dismissed. It was filed an appeal. Appeal also has been dismissed. The similar matter, again they have filed an application, and another union has gone to the tribunal. In spite
Yes,
of
here
this,
the tribunal's award is in
spite of-
favor
but in
favor
spite
of the employees, workmen.
Yes, my lord, in spite of the judgments referred, in spite of the fact has been mentioned in the WS, but it has not been considered only on the question of Abani Mohan's judgment evidence, which is not also complete. The tribunal has.
I'm asking the only witness you
I can clarify from the witness that it is no witness at all with regard to the engagement of the 254 laborers. But if I can show to your lordship from the witness evidence, I can show to your lordship. They have given an oral evidence. Oral evidence also not satisfactory. Also, I can show to your lordship from the.
I will not assess the evidence.
But
I have only asked you. Your witness has said that your witness has nothing more to say apart from the documents.
Apart from
what are the documents?
I have called for the entire records. Well, he has not
So you
filed any
need
documents.
time, are the records with
No,
you?
no, not documents, only the documents which have been referred in the written statement. But there were two judgments mentioned in the paragraph. One is, I have the copy, the judgments are also annexed in the writ petition. The one single bench judgment of Justice Pratap Rai, and against that appeal has been preferred to Justice Nijjar and Justice Pinaki Chandra Ghosh. That is the two judgments they have
Apart
relied.
from that, not they have relied. What has your witness relied upon?
But our witness has relied,
Why
not they.
should they have relied?
Our witness, but the man, Mr. Das, our witness, Mr. Das, he has said, man, whatever is in the record, I shall say on the basis of the records. But in the written statement, it has been clarified that, well, there are two things. One is the storing agency system abolished is been confirmed by the Honorable
So
Supreme
how
Court.
has he given factual evidence? So all the evidence that they have orally given remains uncontroverted?
Yes, but it has been controverted. I shall show from the judge. That's why, my lord, I've also mentioned in the notes, my lord, you have lots of asked me to clarify. I also mentioned in the notes, and I shall, if you also give me an opportunity, I shall show from the evidence.
So you have the opportunity. Do you want to take the opportunity today? That's what I'm asking you.
I shall. Joseph রেগে যাচ্ছে গো, একটু time.
No, you want what do you want? You have to tell me.
My lord, factually,
Kindly give him some time.
well, fact. 9 তারিখে কি আবার টাইম নেবেন?
করে দে না, করবি না, জজ সাহেবরা রায় দেবে, না দেখে দিয়ে দেবে তোরটা।
আমি সেটাতে বলছি যে ফ্যাকচুয়ালি
অ্যাপিল কোর্টে গিয়ে বলবি জজ সাহেব শুনেন।
মানে ফ্যাকচুয়ালি কি আমরা এখন বলে দেবো, কি আপনি বলবেন না কি তাহলে ওটা?
আমি তো
then factually, my lord, the point which I can address it to your lordship today.
You are asking for time. He's
No, let him. No, I always argue on the point of law. Always on the point of law.
yes, but the judgments say
So far as
the judgments say that the question of evidence has to be analyzed by the tribunal. And this court, unless there is no evidence at all, cannot reassess.
That the evidence must be supporting the law.
Yes.
Any evidence will not be.
No.
Therefore, when the tribunal has taken up an issue which was not espoused by the union, recognized union, or by the workmen, the reference comes back. It has to declare. That was my first point.
Yes, that I have understood, but there are several judgments which one has to distinguish. These judgments have been cited by Mr. Chatterjee. It has interpreted section 10 in a way. So these judgments require to be distinguished.
Section 10 will
The contract labor regulation.
Contract labor abolition. Earlier, case
yes, I remember what you have submitted.
2008.
No. ওইটা বল না
2019-7 SCC ওই 440 অটোমেটিক যেটা হবে না,
নামটা বলো।
এটা হচ্ছে ডিরেক্টর স্টিল অথরিটি ইন্ডিয়া লিমিটেড ভার্সেস ইস্পাত।
Well, there at that point of time, the Contract Labor Regulation Abolition Act was not there. Then, well, it went to the Supreme Court when the Contract Labor Regulation Abolition Act came into being.
Please look at 2019's judgment of our division bench.
এইটা আমরা কি ওরা দেখিয়েছি ভার্সেস ইসকো ভার্সেস ওয়ার্কম্যান অফ স্টিল অথরিটি ইন্ডিয়া লিমিটেড, ওরা দেখিয়েছে এটাই।
আমি বলছি, জজ সাহেবকে বলছি, সেটা আমি at that time the Contract Labor Regulation Abolition Act was not there.
No, it was there. It is 2019's judgment. 2019's judgment.
Yes, it came from the lower court. Contract Labor Regulation Abolition Act, it came from the ultimately lower court. The Supreme Court was dealing with it. It was 1990. May I know the name?
No. This matter is Steel Authority of India Limited, ISCO. This is not the division apex court's judgment.
1 minute. At that time, the Contract Labor Regulation Act was not there. No, therefore, my lord, question of regularization. Now, my lord, this law is the regularization. One has no right of regularization unless the statute says.
The reference over here is made in 2005. The act is of 1970.
Yes.
The reference has been made in 2005 in this case.
This case.
Yes.
But the case was reached.
Yes, you have to take into this. This case has to be distinguished because the facts of this case are similar to the case at hand.
As I told your lordship, regularization unless the statute permits, it cannot be done. Unless the statute, one has to support the statute. Supposing I enter through a back door. Earlier, my lord, it was recognized that he is working for so many years. Therefore, my lord, later, 10 years ago, it says that mere backdoor entry will not. That is a backdoor entry, therefore it cannot.
I have understood that point, but despite that, there are several judgments of the court which is analyzing and saying that even if regularization is not permitted, you have to give benefits as par with your regular employees.
Yes, obviously, supposing a typist is doing the work of a court, and the court typist, they will, whatever is given to the court typist, that fellow will get that. That's an equal pay, equal work.
Yes.
Yes.
That has to be granted.
Regularization, that doesn't mean regularization. কি দেখছিস?
আমার কাছে আছে 19 আমার কাছে আছে 30
কি আছে দেখি কোনটা বললি? কোনটা বললি?
সেকশন 10
হ্যাঁ, ওটা দেখতে হবে।
they refer para 34 they refer করেছি
So this one, volume 7, CC, take 1. The আগের চেষ্টা কি ছিল? Initially, the Supreme Court had given one judgment that the moment the Contract Labor Regulation Abolition Act is abolished, these people become direct employees of the employer. They no longer from the date from which they are working. No longer the question arose later that supposing a person enters through a normal course by on the basis of statutory test and whatever it may, he becomes junior. So my lord, it went again to the Supreme Court and said mere abolition of Contract Labor Regulation Act under section 10(1), abolition of contract labor, it does not give a right to the employee to be absorbed directly. He has a right to be considered along with other open advertising. Supposing I am working in the in an organization. Long point. Because Contract Labor Regulation Abolition Section 10(1) for abolition of contract labor, it does not give the right to a contract labor to be engaged directly. He has to come in open competition.
স্পেস এটাতে এইটাতে আছে 19 SCC 33 45 প্যারাগ্রাফ 33 44 45 প্যারাগ্রাফ 33 দেখুন এটা তো সুপ্রিম কোর্ট বলেছে 2009 তে
Earlier, my lord, that the moment the system is abolished, they become direct employees. But later the Supreme Court, in sales case,
Look at this decision of the apex court. Show him this decision in civil appeal number 4152 of 2023. In this case, the tribunal set aside retrenchment and ordered regularization. And this has been upheld by the Supreme Court.
At that time, my lord, not now. Regularization is not an automatic. Even the tribunal cannot grant regularization.
Yes, it has been upheld by the Supreme. Please consider this decision.
Unless, my lord, now the view is different.
Yes,
It has
sir,
become
put the
different.
judgment
Well, unless the statute permits,
Yes, I know, but you have to look into this decision of the Supreme Court.
my lord, now it has changed. That is the difficulty. My lord,
What has changed?
the interpretation has changed. The difficulty is this, my lord, I always say that if a chemist, Bengali teacher is asked to take up chemistry matters, there will be.
Yes, but we also have
No,
to.
judges have to do everything.
We have to look into the judicial precedents. We have to look what can be done. I think Mr. Ghosh, you look into the decision cited by Mr. Chatterjee and come back.
Sir, একদম academic issue.
But yesterday, my lord, I have come across the judgment.
Again,
One
you will
minute,
cite. Every day you are citing.
No, my lord. My lord, one, my lord. Wherein, my lord,
Every day 2, 1, 3.
my lord, yesterday I have come across, my lord, wherein
You
the
almost
Supreme.
appreciate, my lord, at least nowadays.
But
If
I-
law is
I learned-
developing, courts are delivering judgments, he is bringing one judgment every day.
Well, I am learning from him. But but here, my lord, also, my lord, the Supreme Court relies upon that this is a beneficial piece of legislation and you consider keeping in mind the condition of the workers that has to be taken into consideration. My lord. Yesterday, my lord, this judgment has been passed. my lord. Diri, sir. আপনারা ধরুন একটা copy. হুম। হ্যাঁ, হ্যাঁ, copy নেই? Well, here, my lord, the tribunal as well as the High Court dismissed their claim of the workers, stating that they cannot be absorbed or reinstated. But the Honorable Supreme Court comes into their aid, my lord, saying that they has to be reinstated, setting aside the order of the tribunal as well as the High Court. My lord, if your lordship kindly comes to paragraph 12, my lord. But coming to the facts of the case, the CJIT noted that the letters issued by the airlines to the workmen aimed to appoint them for a fixed term. Even though there was appointment orders issued from time to time extended their appointment period. However, an expiry of such period, their employment was supposed to end. It is argued that they carried out work for more than 240 days, which was on a regular and permanent nature. But since the appointment was for a fixed term contract, it would not be of consequence, even though they did work for 240 days or more. The tribunal observed that the airlines had no option but not to renew the fixed term contracts of the workmen due to the change of government policy. Paragraph 16. May I read it? A cumulative reading of the aforesaid clauses reveals that a workman who has worked for 240 days in the establishment.
Here, where is the issue with regard to a contractor of these employees being employed by a contractor?
But here the issue was that
Whether whether these workmen had to be treated as a workman of the establishment. The establishment directly employed them. Where is the issue of the intermediate
I am only relying
contractor?
upon-
Your issue is different.
My lord.
There is an intermediate contractor.
My lord.
So whether or not they could be treated as workmen of the establishment. That is the issue. Have you given him the list of judgments he cited on the last occasion?
But I have given him.
Well, I have given every copy. my lord.
I have given him. my lord.
The division bench judgment of this honorable
Judgment
court?
Which has been relied on by them, I have given. The only thing is this. But I have
তার কপি লাগবে আমি দিয়ে দেবো আরেকবার। অসুবিধা নেই আমার।
the আমি পড়ে জজকে যে আমাকে রিপ্লাই দিতে হবে স্যার তখন দেখতে পাচ্ছি না শুনতে পাচ্ছে না তোমাকে চারটে দিতে হবে
আমি দিয়ে দিচ্ছি স্যার।
The Supreme Court, my lord, abolition of contract labor
I'll give
not
them
make-
the entire set. my lord.
does not make the people
আছে না সব একটা কপি
the employees of the principal of the
Sir,
employer,
এখানে একটা
principal
তো-
employer, save and except where it is found that it is a camouflage.
Yes.
Therefore camouflage has to go to the tribunal.
Yes, it has gone. Now the tribunal has held that they were actually being employed by the
So camouflage,
establishment.
the reference must be that, whether it's a camouflage. Tribunal cannot go beyond the order of reference. What has been referred to it has to determine that.
Please see the reference.
Yes, so Mr. Bhargava.
স্যার আপনার কপি দিয়ে দিচ্ছি একবার পুরো সেটটা দিয়ে দিচ্ছি।
Whether the tribunal could have denied employment.
আপনি পেজ 38 এ পড়ুন পেজ 38
To these 253 workmen.
First is, my lord, these 30s is a mistake on part of the government that employers in relation to the management of employees and their workmen. It's not the workman who has come before the tribunal.
Can you speak on the microphone?
My lord, the point was at page 38. My lord has got. Whereas the central government is of opinion that an industrial leave exists between the employer in relation to the management of IPSI and their workmen. This is the recital part. In any reference made, there is a recital part. That whereas an industrial dispute is pending or is likely to.
Yes, so have you taken this point before the tribunal in the award?
The tribunal, my lord, we have in the
Also,
tribunal.
I
we have
mean,
taken all the points. Also, my lord,
That this point of reference could not have been made. You have taken this.
And my lord, even the schedule, non-application of mind, whether the action of the management of FCI and their storing agent in denying employment to see such and such is not giving them the retrenchment compensation is justified. If not, to what relief? Either it's a management, my lord, employer. Storing agent, if he does something, my lord, the employer is not responsible. Storing agent is an agent. He employ. Yes. Now, even if he's a contractor, there is no question of absorption. And one point is this, my lord, they say all the records have been destroyed.
Yes, I asked Mr. Chattopadhyay on the last occasion. All the records were destroyed, but there was oral evidence in their favor, and it was not controverted by the only person's evidence.
There was controversy.
It was not I shall show you.
And my lord,
Because that person why did you bring him to depose also, I cannot understand. Because he was not in employment during the relevant period. He has been engaged after the relevant period.
no, he can look at the records and see
Yes, that is why I asked him what are the records that he looked into.
records which was existing.
And now he is saying that only 2 orders have been looked into.
Judgments.
2 judgments. How? Then how is he getting the relevant facts of this case?
These judgments have been clear everything. Everything has been spelled out in the judgment. The Justice Pratap and.
No, one thing, my lord, the logic says that if I lose the names of 253 or 254 workmen, how do I get the names?
See, denial malad is at page 94. At last portion is not. They go down, workshop concern or.
As far as the evidence is concerned,
Evidence
page
was tribunal.
146, please look at page 146. What does your, what is the management's witness says?
That is the award portion below. So let's come to the 93, the actual evidence.
He's saying, I do not want to add anything apart from the documents filed. Now, let me look at the documents that were filed. Show me the documents which were filed on behalf of the management.
Documents has not been filed by order the judgment statement. Treated statement.
Please try to see page 146. What does your witness say?
I'm just, it says. the matter
Please
is-
look at the penultimate paragraph.
That is not the judgment, that is the award. So I'm saying.
He is quoting the witness's statement over there, page 146, penultimate paragraph. Please look into that.
My lord, even 145, top Tarapada Ghosh happened to be a storing agent of FCI. I do not know who used to make payment to the 254 persons. This is
This is also your retired employee. Now, please look at.
I do not know whether they were engaged by the FCI, but they were working in FCI. That I know. But they were working in. No.
It's not been said.
Darana, I do not know of any paper to show that these.
You please look at the witness statement made on behalf of your witness at page 146.
I'm reading 145. Huh? I had given certificate of my own. I had no authority to grant such certificate. The company's witness is saying.
He's saying, I don't want to add anything apart from the documents filed.
I do not know Rule 41 of FCI staff regulation, that is page 145. Even Tarapada Ghosh happened to be a storing agent of FCI. I do not know who used to make payment to the 254 persons. I do not I do not know whether they were engaged by the FCI, but they are working in FCI, that I know. I do not know of any, these are evidence, even if it's then 246, you're also 146. The Food Corporation of India, on the other hand, could produce only the witness in the case. It is relevant to observe that the attempt was made in the part of the issue to produce any witness. On their behalf, we have personal knowledge of workings at the relevant time. The FCI would examine only one, Somendra Kumar Das, who was posted as assistant manager at the office of the district manager. Siddharth was examined. Then I am working as assistant manager in the Food Corporation of India under district manager. I am posted there since 1997. Presently, I am dealing with the present matter, and therefore I have knowledge of the facts of the case. The matter relates to 1990. My knowledge is derived from the documents submitted on behalf of the management. I do not want to add anything apart from the documents.
That is why I have told him that what are the relevant documents. This is the reason.
তারপরে তো আমাদের পক্ষে জাস্টিস প্রতাপ রায়। Now, my lord, in paragraph 16 at 148, No, no, no. In such view of the matter, logic ta bolchi. I hold that the demand of the workmen represented by Chonditola Dankuni FCI storing agents, Mutia Muzru, for employment of C. Bhagirath Mahapatra and 253 others as per the list enclosed with the orders of reference copy enclosed is justified, and accordingly they are entitled to get the employment with effect from 1st July 1993 under Food Corporation of India, Chonditola. In this context, I must also make it clear that these 250 workmen are not entitled to get any back wages. But the learned judge was conscious of the fact FCI and these FCI Fertilizer Corporation, these are grounds, my lord, breeding grounds for corruption. 254 employees, I do not know the name. He will say, this is the employee. Most of them I shall show is from Orissa.
Yes, they might be from Odisha, but there
But
are
it
so
has-
many laborers who are from Odisha, Bihar, Jharkhand.
No,
Doesn't mean that they are not employed here.
and he says that these things are lost.
Yes, and now you don't controvert it.
No, it is lost.
Your witness, you bring someone who has got no personal knowledge. Why did you bring someone?
But when he says that my documents are lost, he has to show.
But his oral evidence is there.
Oral
It
evidence.
cannot be that only documentary
The
evidence. will be
tribunal has
relied
to
upon.
consider. My lord, something is entered. This my brief is lost, and then I say it is lost.
I need to look at the documents, Mr. Chattopadhyay.
But the documents, you'll also kindly see at
All from Puri,
WS, you'll kindly
all from Puri, 500 and
page 75, 76.
75, 76 there.
Subparagraph 3 and subparagraph 6.
75, 76.
75, 76 of the repetition. Subparagraph 3, subparagraph 6. There are three, the one of Supreme Court and the General Judge.
75, subparagraph 3.
Roman 3.
Yes, it is stated.
It
Discontinuance.
is stated that FCI adopted a policy decision in the year 1985
To discontinue.
system, and as such, the contract with Mr. Tanabada Host was terminated in view of clause 37 of the said storing agency agreement with Southern Church and
State claims.
and has claims to the alleged workmen for the said storing agent Tanabada Host, whose agency was on
Commission, this is by virtue of
of agreement
which was terminated
long back in
1990.
1990. Therefore, after 1990, there's no question of engagement. Now it's not tenable and maintainable in the eye of law. More particularly, when the abolition of termination of such agency has been justified by the Honorable Supreme Court. The Supreme Court judgment has also been relied. It is also there in the petition at page 103. Well, next, let's kindly come to page 76. Page 76, subparagraph 6. Over and above, a section of the persons who are working on the storing agent Chonditola have filed a petition on Article 226 of the Constitution of India, being the WP number certain such
In the same-
with respect to the
same cause of action.
and demand for absorption of 599 laborers of Dankuni FCI Somik unit FCI
Was dismissed.
Somiti, and the said application was dismissed by the Honorable High Court of Calcutta. Against the same, appeal was preferred before the Honorable Division Bench, which again dismissed, and thereafter no further action has been taken by them pursuant to the against of the Division Bench. For these two judgments are
এর পরেরটাও under one storing agent কাজ করছিল. Hence taking into consideration the
Hence, taking into consideration the claims of two separate unions who happens to be the handling worker
under one storing.
under one storing agent, the godown having a capacity of only 1500 metric ton. It may be deduct that some claim of
Reduce.
number of workers is quite impractical and inflated by it, and FCI cannot bear the brunt of liabilities of the storing agent in any way. I will also kindly come to the said judgment. It is appearing at page 120 of the writ petition. So kindly come on, 120.
Yes.
So I am showing you lots of relevant paragraphs. 120. The first will also kindly come to, I am reading this is a petition has been filed claiming right to be appointed as employees in the regular structure of FCI, a body corporate is a certain such. The following clear, please kindly come to page 121, last paragraph. That the petitioner who are members of the petitioner number 1, that means the Tarapada Ghosh were appointed and labor as labor under respect number 10 Tarapada Ghosh, who was an agent of Food Processor India in terms of statute then Food Processor India Act for loading and unloading of food crates in the godowns of railway sidings, claiming their right for permanent absorption. The petitioners moved one petition on number 725. But this petition was dismissed by Justice A.K. Ganguly by the order dated 9th November 2020 on the ground of non-joinder of Food Processor India was considered by the court as a necessary party in the proceedings. The petition brought the same matter certain side. Now you will also kindly come to page 125 of the judgment. Very short question involved in the matter. The thought that this stated that the regulation is not a mode of appointments having regard to the rival contents of the parties. Very short question involved in this matter as to whether the petitioner are entitled to be regularized as an employee of the admitted fact that by them that they were engaged by a statutory agent. This would not tell that an advocate for the petitioner support the contentions cleared up some several judgments. I will also kindly come to page 128. Page 9 of the page 9 of the judgment. Since no document, last part 8 lines, since no document have been produced to prove that Food Processor India either had employed them or paid their wages and or maintained supervision of their work and or supervision of workers, this could be satisfied with the contents of the Food Processor India that Food Processor India had no relationship with the workers of the agent. It is not liable to regularize the service of the way by absorption of the workers. Now we can also kindly come to page 135.
Last paragraph. Hey, having regard. 135. Having regard.
Yes, page 135. Having regard architect. Page 134, last sentence. Page 134, last sentence. It has been proved by the document that some workers were engaged by the Shadow Agency host who had the relationship with FCI as a commission agent. Delivered the goods to Food Processor India for maintenance of the godown.
His own godown.
It is also on record proved that she host, the Shadow Agent of Food Processor India, had engaged some of the petitioners' workers for the purpose of loading and unloading of the goods of the Food Processor in his godown.
Own godown.
In his own godown and the railway siding. Hence, it is proved that Food Processor India never engaged the petitioners for their service. Accordingly, this court is of the view that the Food Processor India has no legal responsibility and or duty to regularize their service under the Food Processor India. Having regard to such and mere particularly having regard
More
to
particularly.
having regard to the
Stringent.
stringent view taken by the apex court on the issue of contract labor. First, in the case of Steel Authority of India Supra, holding in detail that the contract laborers ipso facto got no right to regularize in the case of the petitioners, or to the status of contract laborers, or to say casual workers. The case by Food Processor India is not legally actionable, and for any read
Or mandamus.
first necessary comment directing the regulation of the service is the application stand dismissed but no rest to court. But thereafter, against this, I want to show some more paragraphs of this the judgment about the engagement. Page 123. Page 123 also kindly come. 123. Now, on the beginning portion, the petitioner is addressed to the workers. And will also got that. Page 123 after 5 lines. 1, 2, 3, 4, 5, 6, 7 lines. The petitioner addressed where the workers and the Tarbada goes. I will also got that. Tarbada goes.
who was nothing but a statutory agent in terms of the agency, has granted in his favor, allowing him to distribute books for the book India through his agency to respective customers by maintaining his own godown and by clearing the goods from the railway siding. The respondents further contended that no appointment letter was issued by the Food Processing India appointing such workers as casual laborers or the workers of the organization. Referring to contention of the application answer page 105 and certainly it has further been contended that only 22 names have been mentioned by the statutory agent Tarapata Ghosh in his letter dated Satansa, clarifying that the employment as laborers to load and unload the goods of is for 5 years only. So far as the other names of the 64 candidates whose names were mentioned in the answer here page 106, it is contended that the said letter was not even signed by the concerned agent. It is contended that employee engaged by the statutory agent cannot claim any right to be absorbed in the FCL. It has been asked vehemently that the statutory agent, when their agency were terminated, moved the deputation claiming the right to continue as agent on urging fate of different laborers engaged by them, and this application ultimately faced dismissal by the Apex Court of India, holding it today that India has the right to terminate the storing agency. The provisions of statutory agency ultimately was abolished, and the statutory agent failed to succeed in the repetition even after the Apex Court on the failed to validity of such abolition. In terms of the judgment of the Apex Court, ultimately, long back statutory agent has abolished on 30th April 1990. However, the witness given open mode says that he has heard that they have worked in 1992. Now, just I shall show you a communication opening mode. In respect of agency, respondent number 10, Tarapata Ghosh, judgment of Apex Court holding in the validity of such abolition of statutory agency is already reported in the judgment passed by the past in the case of versus Jagannath Doctor and others, debuted in AIR 1990. But judgment is appearing at page 103. I have given in the note. It is contended vehemently that after abolition of the agency, respondent number 10, State of West Bengal has been granted right to distribute the goods. After long 2 years of abolition of statutory agency, respondent number 11 recommended the names of 22 persons clarifying their works under him, which is absolutely a false statement. Certificate of respondent number 10 at page 107. Privacy, a document based on a false statement as issued in the year 1992, and this is after 2 years of abolition of statutory agency of Tarapata Ghosh, since the said gentleman had given a certificate that these 22 persons worked for last 5 years, that is from 1987 to 1993. 1992. Though the assignment as agent was terminated in the year 1990, once the statutory agency was established, abolished, there is no question of giving any work to the said in India after 1990. Or it has been categorically stated. And the kindly come, but this is the judgment. But this judgment has been upheld by the division bench. But I have a copy of the judgment, but I shall judgment. The judgment against that appeal has been preferred by them because you can see the judgment.
So citation time.
Judgment. This is sincere. But this is not, we have heard the Learned Council that in 2008. 2008. We have heard the Learned Council the party has claimed, in spite of the law being laid down and reiterated by the Supreme Court before a judgment, contract workers employed by the contractors in which cannot claim request and organization which the contractor has entered into the relationship. The employee of the contractors continue to make some service. The reputation has been filed by a union known as Chombitala Colon Sumiti, claiming that the workmen were first members of the union were entered to be appointed as an employee welfare from India. The petitioners are members of the petitioner number 1 union. They were appointed as laborers under respect of K. Tarapata Ghosh, who was agent of Huttus India in terms of the statute. Some of the statute named the Huttus India Act for loading and unloading of drugs. The workman had been seeking relief and the number of petitions which have been consistently dismissed by this court. The present petition has been filed, but judgment has been quoted ultimately to paragraph number. Ultimately, justice authorized observation has been quoted everywhere. This is page 7, the last observations in our opinion that fully applicable to the fact of you see movement in the appeal is according to dismissed. But this appeal also dismissed. Well, the now university kindly, if university permits me, I want to cite I kindly come to the witness which Mr. Oboni has said, which is totally against the judgment, against the observations of the High Court and approved facts of the Honorable Court. You also kindly see the Oboni's witness as page 95. You kindly state has come to the Oboni's witness.
বাইরের ইউনিয়ন সেটা কেসগুলো দিয়ে দেবে
আপনি বলবেন কোন কোন this is the witness by which 93 or this is 93 this Oboni Mohan is 95 upon which the judgment the order 95. But may I read this date page 1.5 page witness? May I read this?
Page 95.
Page 95. The witness of the workman. On the basis of this, the award has been passed. Each and every line has been a false statement. It appears from the judgment. Yes. But this is the evidence given him. Given in this case, I am reading now from the first line. I used to work in the FCI. I was on deputation in FCI from West Bengal government. I was on deputation from 1981, 1992. I was deputy to FCI. I was working at Dankuni. I was working at Dankuni in the siding of FCI. I was posted at Dankuni in 1986 and worked there till 1992. Bhagirathi Mohapatru also used to work there. His statement. There are many persons like him. Who are many persons? Whose name is this? Nothing. Like this. They were engaged in the work of loading and unloading. But who are they? Nothing is there. I saw them working from 1996 till I was there in 1992. I saw them whom I saw, nothing is there. But 1992 cannot be because not the judgment of the Justice Podam Rai. Also, the division bench has said 1990 when the Tarapata Ghosh agency has been discontinued, closed. There cannot be any question of giving further work by Tarapata Ghosh to any person. Therefore, this statement is totally false. I used to supervise the work of loading and load. Now we'll have cross-examination, you'll Spanish. But the chief what they have said, it is clears nothing. Cross-examination. I used to maintain the attendance of those persons. Maintain the attendance of those persons. Which persons it doesn't matter. There are no lower division clerk in the FCI Dankuni. Apart from me, there was another agency there, is SK Das. So SK Das was there, he said 19. I know Bhagirathi Mohapatru as a labor Sardar. I learned from the laborers that Bhagirathi Mohapatru was running a union. Which is the union? What union? Where they work? Nothing. I learned that, but it's not his evidence. He learned that there are 254 members of the union. I learned that. It's not a direct evidence. I have heard that those 254 persons who are working there. I have heard that. It's not a direct evidence by tribunal can justify cancelling the observation of the Honorable Court and division bench. Tarapata Ghosh supposed to be a storing agent of FCI. I do not know who used to make payment to the 254 persons. He doesn't know who has made payment to which 254 persons. do not know whether they were engaged by FCI or not. But the question is this, has to be engaged by FCI, has to be an appointment letter, and has to be the question of perennial nature of job has to be done by them. Nothing. But they were working in FCI, I know. I do not know any people to show that these 54 persons were appointed engaged by FCI. He has not said. But now LOC kindly 96 is very important. I do not know Rule 41 of FCI Subregulation FCI 1971. I had given the certificate regarding the work of Bhagrat Mohapatra. He has given a certificate. This evidence is so enthusiastic. He has given a certificate. But I do not recollect the time when I given it. I had given the certificate of my own. I do not have any authority to grant such certificate. Basically, see, this is the Xerox copy of the certificate bearing my signature, but no date is mentioned in the certificate, marked as exhibit M1. But I said, show the certificate also. It is not a fact that I had granted the certificate for my personal gain. It is not a fact that for that reason I did not mention any date in the certificate. I do not know that I had no authority to grant such certificate. It is not a fact that the whatever I have stated are all incorrect. Now, one thing has to be also kindly bear in mind. Kindly come to page 95. The persons when he has given this witness, he has retired. He has kindly see occupation retired. Now he has kindly come to the certificate which he has given, page 67 of the report. Now, before going to that, if we go to the evidence of Abhinimohan Bhattacharya, but is there one government service? If he has to, based on an evidence of the persons, which persons were working that, no proof, no name, nothing, no identity. He has not seen that, then they're working. But his language says that I have heard, I have learned. It is not a direct evidence by which the tribunal can direct 254% as an employee of FCI. Huge burden of government exchequer has to be loaded. Because kindly see, this is the only evidence. Now you also kindly see the certificate, how he has issued the certificate, page 67. Good job. I have translated my, I have typed out this certificate in my little notes and argument. So reading from that. Now, kindly come my note at page 10. But also I am reading that. You also kindly see it from the certificate itself. I am reading from my. It is there. No letterhead. You also kindly click. No letterhead. Page 67 of the report.
Yes, I'm looking at it. Yes, I'm looking at that.
To whom it may concern. Bhagirathi Mohapatra, Secretary of Mrs. Choldukala Dampuni FCI Road Agent, Mutiamur Union, along with their loading and unloading laborers, continuously work towards loading agent contractors Tarpada Ghosh on behalf of FCI, storage godown at Chonditala through Dampuni siding under the district manager FCI District 50 West Bengal. During long period of their works from 1983 to 1992, satisfactory service have done. Bhattacharya, site in charge, PM Hoopi, or no rubber stamp, no date, and this also kindly sees 1992, when it has been already been decided by the Honorable High Court in several petitions that 1990 the work of Tarvada was discontinued and abolished. Now, the question of engaging up to 1992 cannot be there. Cannot be there. Now, you also kindly come to another thing. You also kindly come to the witness of FCI with regard to the working status there. You kindly come to page 93 once. Now, by this witness, people can get service. But I have seen so many persons working in FCI without identification. Let them on the basis of that, if the engagement is given. Also kindly see page 93. I am reading at page 94. From page 92, 93, last portion. Previously, FCI was receiving stocks from North India, storing it either in its own godown or higher godown in the distribution of the local sale. Own godown or higher godown. Now, presently, the procedure and distribution has been taken over by the state government. Basically, 94. Presently, the work of FCI is limited to receiving and storing of stocks. The process of receiving, storing, and distribution earlier used to be a regular continuous process. The Dankuni was a rail-fed godown. Dankuni was a rail-fed godown. The food grains were brought to the godowns by wagons in rail, but it is present position. The FCI godown was constructed in 1992. Present godown. Previously, there was higher godown, which was not within the premises of FCI. And it was not well fed. But the persons who were working in Tarpada Ghosh, his own godown, he kept the goods. It was not well fed previously. Previously, the articles were loaded from the wagons, used to be cleared by heads to the godown, heads by by heads to the godown. For this job of carrying the bags containing food grains to the godown for stacking, the FCI did not keep its own laborers. But having storing agents, and they were used to engage the laborers for their same. FCI used to pay only storing commission bill. We did not pay anything to the laborers. That means, well, after abolition of storing agency system in 1990, it is not a perennial nature of job for FCI. And earlier also, as it was had go down, that's why FCI had to engage storing agent. But the storing agency has been discontinued by FCI, has been approved by the Honorable Supreme Court. The judgment is at page 103. Therefore, my lord, the question of absorption, even in the contract labor declared bad, but has to be there when it is a SAM contract. When it is a SAM contract, when it is a perennial nature of job. Well, from the judgments, from the depositions Lordship has gone through, that it is not at all a perennial nature of job after 1992 to FCI or after 1992 to FCI, because at that time which was there, the policy decision has been changed. But there are so many judgments that when the system or the purpose for which the laborers or contractors has been taken, if it is over, there is no question of further absorption when there is no work for similar time. Now presently, earlier there was not rail-fed go down Tarpada Ghosh. It was by his own labor, take the goods from the railway to by head to his go down. Now it is a rail-fed go down of FCI. Railway came to the go down straightway. No question of labor is required for carrying the goods from railway to the go down. Therefore, it is not at all a perennial nature of job. Question of secondly, the question of denial. Now, you kindly come to page 94. Page 94.
103, you said?
103, I shall complete. Page 94, the witness, you kindly go. So 94, second paragraph. It is not a fact that after construction of the godown by FCI in 1992, the workmen concerned were directly engaged by FCI and they were also being paid by FCI. I do not know Abonimon Bhattacharya. They say that I have heard this name from the secretary. He is working as Dankuni Conditional site at LDC. His duty was to assist in charge of the FCI Dankuni. But now, skipping that, it is not a fact that the workmen concerned were engaged at Dankuni by FCI for loading and unloading. It is not a fact that I have come to depose falsely. Therefore, these
you know, you just kindly come to the
I'm asking you whether the directions or the observations made by the coordinate bench related to these laborers or not.
related, not related to this defense, but related to the work done by Tarapada. Tarapada was under whom the FCI was working.
And it's in relationship with the same go down.
Same go down.
Only go down.
Same work, same go down. The Tarapada whose relationship with the FCI, if it is established by the honorable court, by division bench or single bench, that those persons are not able to absorb several liquids, not only one, several liquids. Now they have come forward in before the tribunal. Before the tribunal, the evidence is fishy. It's cloudy. Who is the person? Whom we have seen the work? The chart list of the persons has not been signed by the workers. It has been signed by only Bhagavad Mahapatra. I shall show the list. It is only signed by Bhagavad Mahapatra. He's also his evidence. But the workers are not signed. Who is there? Is not there. You'll also kindly come to page 84 of the reports once. The WS filed by the laborers, filed by the FCI before the tribunal. All these facts has not been considered by the tribunal. Only by the FEC evidence of BANERJI.
Why did you not give proper evidence? What prevented you from giving a proper evidence?
What is there? I do not have to say anything more. Whatever is there in the records. This record is there, the judgment has been produced, the division bench judgment has been produced.
Now the record does not pertain to these people who have come.
No.
He could have said, he could have denied. He is just saying that I don't want to have to say anything more.
Kindly come to page 84, page 84 once. Well, we do not know the persons who are working there.
Ultimately, judgment is so
Well, page 84, subparagraph 5. See, Bhagavad Mahapatra, Secretary Chonditala Dampuni, FCI Stoning Agent, UTM Union placed before the ALC Central. Judgment See, Bhagavad Mahapatra, Secretary Chonditala Dampuni, FCI Stoning Agents, UTM of this union, placed before ALC Central a demand of absorption of 200 regular, 1,000 casual workers in FCI. Now, this concerning to this reference, same reference. And not he pleaded a demand of 254 laborers, and now he's pleading a demand of 254 laborers. That aspect should also be considered by this honorable tribunal, that whether the statement of such persons could be denied or not. But in a LC, he said, I have 200 laborers and 1,000 casual laborers.
How are we concerned with that? A reference has been made with regard to 253 laborers.
But reference has to be made. That doesn't mean that has to be proved before the tribunal. Authority has sent some names to the. You also kindly see the chart, name of the chart. You also kindly the list of workers is 53. 53. 53.
Page
53 of the rate petition. It has to be proved by someone. The learned tribunal has not proved anything, has not got any concrete proof. Page 53, name of the worker, list of 254 workmen. You can see page 100, page 1, 2, 3. There are several pages, no signature by any person. Can you see? Not signature by any person. 59, 61, 62, 64. You also kindly come to 63. Bhagirati Mahapatra.
Yes.
He is not God. He has to sign, he has to take signature of all the persons. This list was forwarded to the ALC, to the authority. What authority with the reference has sent for the adjudication. Whether these laborers are there or not, who was the name? The witness has not said anything about these laborers. He said, I know, I have, if you also kindly come to the witness once. He has said,
I saw some people working. He has seen some of the people working.
Some of the people. Who is some? And my lord, with regard to this person, I have heard that this person is working. I have learned that these are the unions members. I heard, learned. This is an evidence to be considered by a tribunal in giving judgment in favor of the laborers without any concrete proof. without calling any evidence there.
No reason given. No reason.
No reason has been given. Let's kindly see the reasons given by them. FCI miserably proved. See, but they has to prove their case. The laborers came forward for absorption. 254 persons in a government employee. Per day, their wages is less than a lakh. So it has to be considered. But Supreme Court says that before giving burden on the public exchequer, courts and tribunal has to go into the facts. And thereafter give judgments. There are several judgments. Justice Umadiki judgments has been he has been provided that there no backdoor appointment. But these judgment, but these tribunals order proposes the backdoor appointment by Bhagavati Mahapatra, signed and list. The witness given by a retired person, when he has given this list certificate, he has no authority. The court has considered that certificate.
Show me the documents annexed to your written statement.
Annexed to it?
Your written statement before the tribunal.
Nothing has been created.
So what are the documents your witness relied upon?
This statement, these judgments.
So from where will I get it?
For these paragraphs, paragraph 75, 76 and 84. Paragraph 75, 76.
From the award, how will I know?
From the written statement. From the written statement. These written statement of FCI. He said, what is there in the written, I shall not add anything. But the tribunal should have considered the observations of the Honorable High Court. And
if he doesn't place the documents, what is the infirmity in the tribunal's decision? He has to say that I am relying upon this judgment.
Even if no document has been placed, but is the evidence is proper to give an award? I have heard, I have learned.
There is another person before that. Why are you only concentrating on Abani Mohan's?
But tribunal is a quasi-judicial authority.
Yes.
I have heard that some persons are working. I have learned that those are members. Is it not sufficient to justify the engagement? Now, also, I am referring one judgment also. You also kind of see this. Policy is 1990 to the 1919 7 STC, page 440. I'm referring paragraph 33, 44, and 45.
Wait, first you come to the award.
Come to the award.
Yes.
Award past 137.
Look at page 141.
But you also kindly come to the reference in the award itself, 137. 137.
Will you listen to me or not? Or will you argue on the basis of whatever you feel like? I'm asking you a question. There are 3 witnesses examined in favor of the union. You are referring to only Abani Mohan's witness. Please come to 141 bottom.
141 bottom.
How is this evidence controverted by your witness?
I have 12A.
Yes.
But I have happened to be the secretary of Chonditala Dankuni Mutiapus Union, which espoused the reference. Earlier, I used to work at Chonditala Dankuni store sidings. I was working there for 20 to 21 years. I used to work under FCI. The district manager FCI used to make payment to me. I used to work regularly, and the nature of work was perennial. I was engaged in loading and unloading of the food.
For only for him.
Only for him.
You cannot say on the other one.
Only for him, second paragraph.
The FCI has its own godown at Dankuni. I was engaged in the godown itself in 1993, where we were asked to cease work as there was no work left for us and other persons who were engaged. Before my removal, no notice was served upon me. We had some quarrel with persons who were freshly engaged. Freshly engaged. During that period, they quarreled with the persons. The work was stopped. Persons like who were removed were asked to go to Andhra Pradesh, but it did not go.
The district manager was asking for money to continue with the work. Since we did not oblige him, we are removed. In 1997, we received letter from FCI regarding test endurance. I participated in the test. I got through the test till I did not get the service. He said is himself about the 254 workers, particularly who are they?
Yes, see what he's saying in cross-examination. Why do I have to say? You look at the bottom of the page at 142.
All the original documents in my possession were destroyed at cyclone. We had not gone to the Andhra Pradesh, Odisha, because in cross-examination by FCI, he has stated that I have come to depose on behalf of all 254 persons involved in the reference. I am Secretary of the Union since 1993. Since year 1993, well, he cannot espouse in 1993. He cannot.
And your witness can say whatever he wants to say.
Story agent was 93 up to 1990.
Mr. Ghosh, the three judgments have to be distinguished in this matter.
This, my lord, whenever I argue, my lord, I argue only on point of law.
Yes.
Now, my lord, point is this, my lord, espousal is by a different person who are not members, because under the Industrial Disputes Act is the workmen of that institution. Any other person cannot. That was the point I said. And my lord, absorption, the law is this now that he must have qualification. And if it's a statutory corporation, I have to follow what is the normal course of appointment as done in government employees. He must have qualification. There must be a advertisement on all these things. Now here, the law is this on this point.
Yes.
Oh Lord, these, I tell you, Lordship, the hard reality is this: 254, 255 people are there, then these jobs are sold. Jobs are sold. And in Bengali, we say these are the FCI or Fertilizer Corporation. These are murgis. Hard reality. I get an order from the court. I say, yes, this is, for this reason, 255, their records is lost. If the record is lost upon which I am making my claim.
The only thing is that your witness could have given better evidence.
No, maybe. Supposing I don't give evidence.
That is why the tribunal is holding that
Supposing-
the evidence given by them remains
Supposing if
uncontroverted.
I do not give evidence, it is for the tribunal to determine, is to assume that although the defendant is present, he refuses to give evidence. But that does not make, I shall show there is a case law, that does not make what the petitioner, the employee says, that is correct. It has
But
to
how-
stand on its own foot. First is, well,
There is still semblance of evidence for
That
the
first is-
union, but there is nothing from your side.
maybe. But the thing is that, which I said earlier, that on the question of jurisdiction. If I don't have jurisdiction, and if that point is this, that has to be determined by the High Court. I cannot come with a marriage and divorce case before the tribunal. This is a question. No, just don't take it otherwise. It's very, there's a pleasure, we feel pleasure to argue before your lordship, because we can go into various aspects and the law comes out. That is the thing. I
All
think-
right, come back on the next occasion. Please distinguish the judgments he has cited.
Sir,
Ashwin.
very hardworking, my lord. My other side. We take it as.
Come back next Wednesday.
Sorry.
Substantial arguments have been made on behalf of the writ petitioner. In reply, writ petitioner, in reply. Let the matter appear for further consideration under the same heading motion on, same heading, part heard on August 2, 2023.
Feel good. পড়তে ভালো লাগে। Great.
স্যার আমি দিতে পারবো স্যার করে দেবো আপনাকে দিব
ওকে দেব
আমি দিয়ে দেবো স্যার আপনার আগের দিন কিছু আবার দিয়ে দেবো গ্রেট কি কপি করে নিয়ে আসবো আরেকবার দিয়ে না বাবা
509. Why didn't I? 200. I'm appealing for the state.
দেখি পিটিশনার হয়ে কে আছে।
The main respondent is West Bengal Nursing Council.
আসুন। No one represents the petitioner today. Full stop. No accommodation is sought for. Full stop. In such view of the matter. Let WPA 5996 of 2020 bolded be dismissed for default. Bolded. Serve a copy. Unan appearance today.
This is for the fourth time this is for.
হ্যাঁ। You take this point when they file the restoration application. Same order করে দিন 210.
And I'm appearing for the petitioner, my lord, in this case, the Indian Council of Medical Research, my lord. My lord, I'm appearing for the
Give
direct.
me your affidavit of service.
My lord, it has already been served, my lord. No, they have also.
Yes, where is your affidavit of
Well,
service?
must be, my lord, if it is with the record.
देखी affidavit of service
My
आज
lord, because, my lord, they have.
नहीं
আপনারা appeal. But because, my lord, this has already been served, my lord, they had also appeared, my lord, on the last date also when your lordship, my lord, was pleased to dismiss it for default, my lord, then I had mentioned the matter, my lord, on the last occasion when it was taken up.
it's not there in the record and today they are not appearing.
My lord, I have only one difficulty, my lord, in this case. My lord, the Central Administrative Tribunal, my lord, has fixed 28th of July, my lord, as a date for contempt of the ICMR, my lord, for not complying with their order. My lord, just to give your lordship the backdrop of the case, my lord, this particular respondent, my lord, he, on the basis of a fake caste certificate, my lord, this job of his, my lord, as a senior technical officer of the ICMR, my lord, he was given a job. Now, my lord, he used a caste certificate which was a fake caste certificate. But this job was reserved for the scheduled caste. Now, my lord, subsequently it was found out that he belonged to the general caste. Now, my lord, the initiation of this particular proceeding would be, my lord, a case which was registered with the Belegata police station under sections 120B and 467. That is a forgery. Now, on the basis of that, my lord, he was arrested. He was kept in detention for beyond 48 hours. Thereafter, my lord, if your lordship may kindly takes up page 33, but where the problem starts, my lord. My lord, page 33 of my application. My lord, has your lordship, my lord, got? My lord, on behalf of the ICMR, my lord, pursuant to this detention, which was beyond 48 hours, my lord, he was kept under deemed suspension. And he was given a 50% of subsistence allowance. My lord, this was done on 18th of March 2021. My lord,
But how is this writ petition maintainable
My lord-
against this person,
My lord,
against a private
my
individual?
lord, because my lord, this is challenging the order, my lord, of the Central Administrative Tribunal, which is at
So how
page
is it
14.
before a single bench of this court.
My lord, your lordship's determination, my lord, is probably, my lord, with regard to the orders, because the Central Administrative Tribunal, but service-related matter, my lord.
Central category একটা কি করে single bench এ হবে? It cannot be before the single bench. Yes? Yes. WBCT. It
Lordship.
won't be before this bench. আসুন।
My lord, then, my lord, if I could only, my lord, for urgent listing, my lord, if it would be released, my lord, then I could mention it,
I'm releasing it.
lordship. My lord. My lord, for urgent listing, my lord, if you could, lordship could add that, my lord, because.
That I cannot.
Madam, deeply.
This matter. Now, in this matter, the petitioner challenges an order passed by the Central Administrative Tribunal. Full stop. The subject matter of the writ petition cannot be placed before a single bench of this court, full stop. Accordingly, comma, WPA 16370 of 2022 bolded is released from my list, full stop. Petitioner may take appropriate steps to correct the presentation form, full stop. Next. Liberty is given to the petitioner to take appropriate steps for listing, comma, if so advised, full stop. Next, server copy.
I'm so deeply grateful, my lord.
এই WPA টা রিলিজটা বলতে করে দাও।
I am for the state responders.
And I am for the petition. My lord, on last occasion, the deficit question was raised about the deficit court fees, and as per my instruction, it has been deposited on 16/12/2022, which is reflected in that status report also. Sorry, there is some handwritten portion.
Yes, please.
My lord, this matter is about appointment of Anganwadi helpers in the district of Malda.
Yes.
The petitioners have been enlisted, selected as the.
I can't hear you.
Sorry, my lord. The petitioners were selected as AW Anganwadi helpers as per merit in Bamungola ICDS project office, Madnabati GP Malda on 1/3/2011. Thereafter, they were not given appointment.
Yes.
And accordingly, this writ petition has been filed. My lord, I'd like to refer a similar matter which in which my lord has passed an order, which is WPA number 8704.
Oh, এটাই
My lord,
well, the panel has already been satisfied by the district magistrate, and your lordship passed identical case.
identical order, my lord, that has to be passed.
They are similarly placed.
Similarly placed.
And it's the same panel.
Yes, same
Same
panel.
panel, same
Same
area.
panel.
Same panel, same area, my lord.
Already district magistrate already satisfied that panel.
Yes. Ashu. এখানে সব সেম হবে, খালি অ্যাডভোকেটসদের নামটা আলাদা হবে। Deficit court fees have already been paid. এই জায়গাটা are to be paid এর জায়গায় have already been paid by the writ petitioners. Learned counsel appearing for the petitioner for the respondent, ওই জায়গাটা খালি change হবে. Disposed of. Disposed of.
May I appear for petition?
This is
the matter.
we are for the West Bengal Power Corporation.
where for the West Bengal Power Corporation, where for the
West Bengal
opposite party
Power
respondents,
Development Corporation.
1, 2, and 3 Lordship, led by Mr. Ranjoy D.
West Bengal Power Development Corporation my lord, conducted a selection process for filling up the different posts. Petitioner before your lordship applied for the post of my lord, work education.
You have added the registrar.
Lordship, pursuant to your lordship's direction, and we have served also, my lord, there is the affidavit of service. Nirod Kaur, yes. For the Calcutta University already appeared, Mr. Nirod Chatterjee represented.
Now, the day the Calcutta University appeared, you did not appear.
No, my lord. On that day I could not appear. Your lordship was kind enough to restore lordship.
Now, today the Calcutta University has not.
I should wait as your lordship. If your lordship.
Have you
please-
informed him that this has been restored?
Restoration of what this is? Yes, yes.
Please show me the letter.
Yeah, will be mentioned. No. Restoration of what? Restoration of what?
23/6 হয়েছে restoration আর এটা আপনার এই 4
So after your lordship restoration, you have given. And not that ATM Bhagalpur University, your lordship also directed. Till that they have not.
Where have you said that this has already been restored?
That restoration word is not there. I have seen your lordship.
You have said that it will be
Restoration order
mentioned.
is 23rd June.
So he has not
Yes, yes.
indicated.
No, restoration word is not there. Only I have communicated that we will mention.
Mention
yes,
then.
mention. So I should come with the further notice.
Ashun. This matter was restored by an order dated June 23, 2023. Full stop. On April 13, 2023, when this matter was dismissed for default, Calcutta University was represented by Mr. Nilotpul Chatterjee, learned advocate. Full stop. However, no one represents the Calcutta University today. Full stop. Neither could the petitioners, neither could it be submitted on behalf of the, neither could it be shown, on behalf of the petitioners that the respondent stroke Calcutta University was informed about the order of restoration. Full stop. Next. Let another notice be served on Mr. Chatterjee, learned advocate representing the Calcutta University, along with the adjourned date of hearing. Full stop. A proof of service shall be filed on the adjourned date of hearing. Full stop. Let the matter appear for further consideration under the same heading. এটা কিসে আছে motion, bold motion on August 9, 2023.
Lordship. I will also serve notice upon Bhagalpur because
Yes.
pursuant to Lordship's order.
Calcutta University and also
And Bhagal, TM Bhagal.
Yeah.
9th August.
Same heading.
One 114, my lord, I am for the state respondent.
For the petition order.
Now, my lord, the principal grievance is
The last
Can
occasion, my
redress,
lord,
my lord.
on July 19th, my lord has passed direction, my lord, directing the respondent numbers 3 and 4 to appear, my lord. And my lord, because my lord, this respondent number 4, my lord, who has retained the sum. My lord, kindly, my lord, takes, my lord, MC the petition as a doctor, my lord.
that I have. Where is respondent number 4?
my lord, respondent number 4
Because the money is with respondent number 4.
Respondent number 4.
has been made.
Hmm?
Payment has been made with interest on 27th April 2023, a sum of rupees 2,27,856 with interest. 27th April, আমি রিসিপ্টটা দিয়ে দিচ্ছি। My lord, your lordship, let my learned friend take instruction, my lord, that
Payment has been made.
payment has been
I'm
made.
not aware of that.
I have the instruction, my lord, that
sir.
27th April 2023 payment has been made.
Then in July, why am I passing this order?
My lord, I don't have instructions such, my lord. But my lord, it is only regard to the, if it is payment has been made. My lord, it's regarding to the provident fund only, my lord. My lord, there are other retirement dues even, my lord, with regard to the gratuity and leave benefits even, my lord. Can you, my lord, takes, my lord?
But perhaps, my lord, the writ petition is not maintainable, my lord. It's a
My
civil
lord, payment
post
is required to be.
under the health department.
Yes. Can you, my lord, takes, my
Have you
lord?
taken it on the first day? Point of maintainability?
On the first day.
Yes,
of-
see whether you have. Now, the thing is that you please come to your prayers.
Yes, my lord.
What have you prayed?
My lord, page 11, my lord. To disburse the entire balance of PF, my lord, that's the
Then,
prayer day, my lord.
yes, then. Where have you prayed for gratuity in your writ petition? Look at prayer A and prayer E.
My lord, other service benefits, my lord, what they asked for, my lord. The prayer B, my lord, it's other service benefits, my lord, they've asked for, my lord. I mean, the retirement benefits, my lord, the provident fund along with, my lord, the pension, my lord, coming under the other service benefits, my lord. And my lord, the letters also which I have issued, my lord, page 26 onwards, my lord. Page 26 of the writ petition, my lord. The second paragraph, my lord. You read out, my lord. Consequent upon voluntary retirement from the services after the rendering the same the span of 15 years from 10 months, 5 years, I'm entitled to the
Page
term.
number?
My lord, page 26 of the writ petition, my lord. Second paragraph, my lord. That what I've asked for, my lord.
Ashun.
And my lord, page, my lord, thereafter, my lord, page 36. That has what been, my lord, cleared, my lord. Letter issued by respondent number C to accept, my lord, my retirement benefits, my lord.
Mr. Mullik, learned counsel appears on behalf of the petitioner and submits that not only the balance amount of provident fund dues have not been disbursed by the employer, but also his gratuity and leave encashment benefits have not been disbursed. Full stop. The petitioner retired from service from the medical college, comma, Kolkata, full stop. Retired from service as the chief executive officer of the medical college of the Calcutta Medical College, full stop. Next. Mr. Rai Mukherjee, appearing for the state respondents, submits that the writ petition is not maintainable as the petitioner is a government employee. Full stop. However, this court finds such point of maintainability was not raised at the first instance when this court considered the claim of the petitioner on July 19, 2023. Full stop. Judicial time was spent in appreciation of the facts of the case on that day. Full stop. Next. Mr. Rai Mukherjee further submits that the balance sum of rupees 1,70,194 on account of balance provident fund dues have already been paid on
27th April 2023 with interest.
On April 27, 2023, along with interest. Full stop. Along with interest thereupon. Full stop. Mr. Mullik is permitted to take necessary instructions with regard to whether such balance sum has been paid. Full stop. Next. This court permits the state respondents to bring necessary instructions on record with regard to the admissible dues or with regard to the admissible dues on account of gratuity and leave encashment benefits payable to the petitioner on the adjourned date of hearing. Full stop. Let the matter appear for further consideration under the same heading motion, bolded, on August 9, 2023. Full stop.
Well, may I just indicate one thing, madam?
Serve a copy.
Well, we sent all the documents with regard to the service, career of this petitioner, to respondent number 5, the principal accountant general.
He appeared. Yes.
They have to take a decision on this because there are certain dispute. There was unauthorized leave. The service was not. The government didn't make the service permanent. Therefore, this issue has to be decided by the.
You say that on your written instructions.
But we sent all documents that I will disclose.
You say that you have sent all the documents and the decision is to be taken by the principal accountant general. Because on the last occasion they came and submitted that whatever was due and payable on account of provident fund dues, they have sent it to you.
The AG Bengal, my lord, issued this notification that to pay 2,23,000. So we paid immediately.
Yes, 1,70,000 plus interest.
Plus interest, yes.
And they have disbursed the funds to you. That
Yes,
they have
yes,
said.
yes.
So that's why you have already paid. This writ petition was filed in January. You have paid in April. So as far as the writ petitioner is concerned, there is no suppression of material facts. Only thing maybe Mr. Mullik was not aware of the
payment
of
was
the
I don't know.
payment,
Actually,
on the last occasion.
Yes.
Because this was dismissed, again restored. So
Yes,
it has a checkered history. Now only with regard to leave encashment and gratuity.
Very well. I shall take instruction that when.
Yes.
I'm grateful, my lord. Very grateful.
My lord, in this matter, I beg to appear for the petitioner. I am led by Mr. Shoma Mojumdar, learned advocate.
1 second. Mr. Rai Mukherjee. Also, you have to, because as far as gratuity is concerned, you also have to say that if there is any disputed amount and if you have deposited it with the controlling authority, you cannot push that responsibility on the principal accountant general.
There is one thing, my lord, that the qualified service for getting gratuity is at least 10 years. Now, the service, my lord, completed by the petitioner is 8 years and few months.
That is all right. That decision you have to take. How can you, and if there is any dispute, you have to deposit the admissible amount with the
authority is the accountant general's office. The final decision has to be taken because as an employer, my lord, we send all documents.
No, as far as the gratuity amount is concerned, how can they take? The controlling authority will take that decision. You have to find out who the controlling authority is. You take all the instructions and come back.
My lord, in this matter, I beg to appear for the petitioner. I am led by Mr. Shoma Mojumdar.
All right.
Learned.
It a key. Group 3 hearing. All right.
This is a list of dates that was direct.
Yes. Yes.
Yes. Well, this was an application filed in 2002, whereby the contractors workers, they are under the Food Corporation of India with 2 FSD at Bhatjungla and Kalirghat at Krishnanagar complex. They came before your lordship with a prayer for the equal pay for equal work of like the departmental workers, equal remuneration as also the equal service conditions, and also departmentalization of the contractors workers. Food Corporation of India and its various authorities are respondents. Along with that, then the contractor was also made a party to the writ petition. Thereafter, an interim order was passed on 11th September 2002, whereby one order of injunction was passed by this honorable court so that the contractors workers may not be disengaged. Thereafter, the FCI authority filed the affidavit in opposition in January 2003. The writ petitioners also filed the reply in February 2003. Long thereafter back, in 2015, the FCI authority filed one supplementary affidavit in July 2015. The writ petitioner has also filed the supplementary reply to the supplementary affidavit also. From 2002 to 2020, January 2020, the interim order was extended from time to time. Thereby, on 16 January 2020, this writ petition was dismissed for default by this honorable court. Subsequently, in 2022 April, applications were filed by which the writ petition was restored, and by order dated 17th May 2022, the order of injunction was reimposed, and that has been extended by time to time, as also by your lordship, till 30th September 2023. And against this application, CAN 4 of 2022, the FCI authority has also served upon us an affidavit in opposition that is perhaps not on record, but it has served upon us. And we have also served upon them a reply that is in August 2022. The affirmed copy of reply
নিশ্চয়ই আছে, তারও আমি আগে দেখি যে কি হয়েছে। একটা কবে থেকে প্রথম আরম্ভ করে Do you have the order passed in 2002?
2002. No,
When did it come up for hearing for the first time? The order I have is of 2003 and it says the interim order already granted.
Interim order was granted in September 11, 2002.
Yes, so I'm asking you, where is that order? আচ্ছা দেখো দেখো না সেপ্টেম্বর 11, 2002 এর অর্ডারটা কোথায়? এখানে পাচ্ছি না। হাতে লেখাই সবকটা অর্ডার 2003 এর অর্ডার গুলো হাতে লেখা, কিন্তু এটা কোথায়, মানে 2002 এর অর্ডারটা কোথায়?
I applied for orders, but I don't have that order. I have only.
Yes, I also have other orders.
Yes, yes.
I am not getting the interim order, the basis on which the interim order has been passed. September 20, 2002.
But when this honorable court passed the order in 2022,
দেখলাম তো বুঝতে পারছি না এটা 11th September 2002
11 September 2002.
কিছু কিছু লেখা নেই এটা। Yes, all right, I found it.
Yes, that order was reimposed by this honorable court on 17th May 2022 because it was dismissed for default. Thereafter, an application was filed.
All right.
My lord, I'm filing the affirmed copy of the affidavit in reply against the CAN application. CAN 4 of 2022.
Yeah. Page. What is the CAN 4 for?
CAN 4 is for reimposition of an order of injunction that was dismissed for default in January 2020. It was dismissed for default. Thereafter, it was restored and an application was filed for
All right.
reimposition.
You proceed with the hearing of the main writ petition.
Main petition.
Because this already interim order has been extended till September 30, 2020.
My lord, that is extended by.
Place the writ petition.
My lord, the contractors workers under the two depots at Krishnanagar, Kalighat and Bharjungla, they were engaged in early years of 1991, 1992. Thereafter, in 2002, there was they appeared before this honorable court with a prayer for injunction because the contractors' works might have been disengaged by the authority. In 2002, their main prayer before your lordship was that, my lord, I am inviting your lordship's kind attention to the prayer portion. That was there was a clear violation of Rule 25, Sub-Rule 2, Roman 5A of the Contract Labor Regulation and Abolition Act in respect of contractors workers of food storage depot at Kalighat and Bharjungla in Krishnanagar complex, and a direction was prayed for in this regard, and there was also a prayer for equal pay for equal work, like this prayer B, as a writ or writ in the nature of mandamus upon the respondents to forthwith grant and pay the so-called contract laborers the scale of pay, hours of work, holidays, and other ancillary and fringe benefits like the departmental workers. As also,
now what is the fate of these people? How
they
old
are,
are they?
they are engaged. They are now still working. Contractors have been changed from time to time, but the contractors workers have not been changed. They are still in the occupation from 10 years before this writ petition was filed till to date. That is almost 32 years they have passed in the that complex for handling an ancillary work. That is not a that is only a manual work and physical work they involve, and not the very skilled work that is they are doing, but they are still engaged. So the principal employer is the Food Corporation of India, and the contractors have been engaged from time to time. They are working on under various contractors. Now in 2022, there was also a direction from the Food Corporation of India for 100% transfer of the departmental workers. In 2022, the application was filed for the reimposition of the injunction only because there was an apprehension that these contractors workers may have been disengaged and they have been transferred and the service conditions may have been changed. That's why we came before your lordship in April 2022, and a suitable order was passed in this regard, by thereby injuncting the authority for the transfer of these departmental workers. My lord, the departmental workers of the FCI, they get regular benefits, scale of pay, holiday, and other education benefits as also the says. But these workers under the contractors, they are paid only a bare minimum. They have not been paid like the departmental workers, but they do the same nature of job at the departmental workers if they are for the handling and ancillary purposes. So this writ petition before your lordship was filed for the necessary direction with the regard for the departmentalization of these workers, as also regular pays and other benefits they are paid to the departmental workers. My lord, in this connection, I am inviting your lordship's kind attention for violation of section 21 of the Contract Labor Regulation and Abolition Act 1970.
এটা একটু দিন না, প্রথম বইটা।
My lord, under section 21, subsection 1 of the Act of 1970, a contractor shall be responsible for payment of wages to each worker employed by him as contract labor, and such wages shall be paid before the expiry of such period as may be prescribed. Next point, every principal worker shall nominate a representative duly authorized by him to be present at the time of disbursement of wages by the contractor, and it shall be the duty of such representative to certify the amounts paid as wages in such manner as may be prescribed. As also, subsection 4, my lord, in case of the contractor fails to make payment of wages within the prescribed period or makes short payment, then the principal employer shall be liable to make payment of wages in full or the unpaid balance due, as the case may be, to the contract labor employed by the contractor, and recover the amount so paid from the contractor, either by deduction from any amount payable to the contractor under any contract or as a date payable by the contractor. My lord, before your lordship, the contractor appeared. They have filed an application so that his contract may not be terminated with a prayer. That application is on the record. I have the certified copy. Thereafter, my lord, I am inviting your lordships to Rule 25 of the central rules under the Act, Sub-Rule 2, 5A. My lord, in cases where the workmen employed by the yes,
Yes. Rule 25.
Sub-Rule 2,
Yes.
Roman 5, small a.
Yes.
In cases where the workmen employed by the contractor perform the same or similar kind of work as the workmen directly employed by the principal employer of the establishment, the wage rates, holidays, hours of work, and other conditions of service of the workmen of the contractor shall be the same as applicable to the workmen directly employed by the principal employer of the establishment on the same or similar kind of work. That was our main grievance. Sir. In this regard, we prayed before your lordship for the departmentalization, as also the same service conditions and pays that we just undergo for regular day-to-day work for last 30 years. This petition is pending for last 20 years. Before that, thereafter 10, 12 years ago, we were also engaged. The contractors have been changed from time to time. We have not been changed. We are still working. And a substantial years of our life we have devolved in this way. And so that we are praying before your lordship for the equal remuneration, equal service conditions, as also departmentalizations, as has been envisaged under Rule 25, Sub-Rule 2, Roman 5A under the rules, under 1970 Act.
Yes. These are your submissions?
But only question is not it's a question of departmentalization of handling laborers. Not- I don't question not the right of an employer to engage workers or employ workers in the manner he wishes to do. But I am only on prevention of exploitation to the extent it is permissible for the court to enter into.
That is the thing. How can the court direct regularization?
Now, there are several factors or facets of service. One may be duty hours, holidays.
Yes, that is, the court can consider whether such payments should be made at par with the regular employees.
Please have a look not at my prayers.
I am looking at your prayers, 25, page 25.
Comply with the provisions of this.
Prayer A, B, I can understand, but prayer F, I.
And I believe
And
there is an
interim order has been
subsisting.
granted on the basis of prayer F.
That has been granted. But not, of course not. Today the question is, if they have been
So for
continuing
20 years, new workmen have been appointed in these two depots.
They are working, they are retiring.
Then what happens?
Not in terms of the settlement, probably some of their heirs are also getting appointed. No, it's a job of handling.
Because for 20
Sex.
years, this prayer has been granted.
But I tell you, Lordship, not it's some of the workers are, what is the difference between the departmental
Mr.
workers and
Mukshundar, I would have understood if it was your disengagement being considered, but for 20 years, prayer F has been granted.
yeah. Not regardless of an interim order passed in this matter, not everywhere it's going on. It has not every type of work has its own uniqueness.
Yes, there is no difficulty.
Now, not
in
the question here is
appreciating that.
a worker who is a departmental labor of FCI. He is, say, putting
He is
this
getting a
stat-
certain amount of wages. He is getting hours, his hours of work are limited. He is getting holidays, all that I can understand.
I don't want parity in hours of work or something like that. Suppose, but when my service is utilized, when my service is being utilized, pay me at least at the same rate.
I understand that point.
Please have a look. It's also my duty to show not only two things. Please have a look at page 51.
Yes.
The first is not, this is with regard to the departmental workers. I claim this relief. Scale of pay, not there are various categories. Third one is the handling labor. VDA above certain points. Then HRA, incentive wages. Please see, incentive wages has two categories. One is up to 70 bags normal wage. And then B, up to 66 feet normal wage. Per day, one has to lift 70 bags. Can there be a differentiation of
quality of work insofar as a handling labor is concerned. That
So what
requires
is the
no,
rate at which you are being paid?
that I am being paid at the rate as described in paragraph 15 of the writ petition. Kindly permits me to place this paragraph. In spite of doing the same and similar kind of work, the so-called contract workers of the two depots have been deprived of all kinds of allowances as also fixed scale of pay. The contract workers of those three depots are not even allowed the minimum guaranteed wages in a month which are paid to the departmental workers. The departmental workers get guaranteed wages for 21 days plus wages for 4 or 5 off days in the month, and for the remaining 4 or 5 days, if no work is allotted, the departmental workers are paid attendance allowance at the rate of half the wage. But the contract workers for same and similar work do not get work done, get payment at piece rate and no payment for the days when no work is allotted to them. An extract from schedule of rates for the services of the so-called contract workers as per existing contract by way of paper arrangement is quoted below. Part 1, receipts, dispatches, deliveries. That is the description of services. The right hand column is rate per 100 bags. For unloading food grains, bags from wagons or trucks or any other transport vehicles and stacking the bags in the shed or on platform or ground of or vice versa as mentioned in clause number so and so. Rate per 100 bags. For bag weighing up to 65 kgs, it's 8.25 only. For bags weighing more than 65 kgs, it is 12.50 only. Now, this kindly have a cursory comparison with that page 51 I was referring to. There is a complete scale of pay with per day basic pay. The very first column. Then there is a
basic pay is 150.
Per day basic pay is 160. There is a scale of pay.
No, handling laborer, it's per day basic pay is 150.
Oh, yes.
150
Is 150, I'm sorry.
for ancillary.
And 147 for ancillary workers. 147.69. That's the departmental workers.
So they get over and above that.
That's minimum. That's minimum per day basic pay.
Per day they will be getting paid at the rate of 150.
150 per day.
Yes. And
in,
then
in the, say, a handling labor, he is born in the scale of 3,900 to 6,860. Per day basic pay of 150. Then he will be having a VDA of 29.3%. All these are adding up to his daily earning. Then, as on 1/1/2002 per day dearness allowance, that's 45.13 rupees for a handling labor. So add 150 and 45.13, that's almost 195 rupees. Then HRA, 9.62 rupees, crosses 200 mark. Then attendance allowance. Handling labor has an attendance allowance of 87.88.
that is in case no work is allotted.
Then incentive wages, up to 70 bags normal wage.
Tell me, when does the incentive wages, when are that applicable?
No, please see serial number 6 on that page.
Yes. When is it applicable?
Incentive wages up to 70 bags normal wage. So up to 70 bags, he's getting say 400 or 500 rupees, adding up all those allowances before. Then I am a handling labor. Rupees 222.40, 71 bags to 90 bags, 8% of full pay. rate per bag per worker is 3.15. So if above 70 bags, one is lifting another say 20 bags, so it adds up to another say 60 rupees or 65 rupees.
No, so this basic pay is paid for what? For
Basic,
just being in the
no,
employment room?
basic pay is say a per day wage has various components. Basic, dearness allowance, HRA, and such other allowance. Now basic is this scale. In the scale, this will amount to a part of basic
So
pay.
this is for lifting of how many bags per day?
That's
The
a
incentive is over and above.
up to 70 bags, there is no, that's the normal work required to be done. Up to 70 bags. Your Lordship will be pleased to find under the heading incentive wages, up to 70 bags, normal wage.
That is coming to 222 after adding the basic and the DA.
Yes. Basic, DA, probably also the HRA.
HRA, yes. So over and above 70 bags, then
Then the incentive of 8% of full pay at the rate of 3.15 rupees per bag, subject to maximum of 8%.
yes.
Then 91 bags to 110 bags, it increases.
Yes.
Then up, no, that's the number of bags. Then please see up to 66 feet. Has your Lordship got that?
Yes.
So up to a height of 66 feet, there will be normal payment, normal wages earned. But say within the 70 limit, a worker is lifting up to 90 feet, then he will be getting this allowance or additional incentive. So the incentives are earned not only on the number of bags, but also on the height up to which these bags are lifted. And there can be no difference. There can be no difference in the quality of work insofar as the handling labor is concerned.
Over here, as per as the contract labor is concerned, it is based on the weight of the bags.
Yes.
There,
And it takes my reading at paragraph 15.
yes,
At
page
paragraph
13.
13. For bag weighing up to 65 kg.
Yes, there the terms are different. It's in accordance with the weight. And over here, it's in accordance with the number of bags, whatever may be the weight, and also as far as the height is concerned.
So not suppose a worker lifts 20 bags a day, he earns 160 rupees.
But anything less than 70, will he not be earning 222?
He will be getting that 220. That's the minimum guarantee.
Yes.
That's the minimum guaranteed.
So up to 70, whether he lifts 20 or 30, up to 70, he will get 222.
That's the minimum guaranteed wage. And then please take the schedule of rates. Oh, I'm sorry, the schedule of overtime rate, paragraph 17. The departmental workers do have fixed duty hours from 10 a.m. to 5 p.m., including half hours lunch break. The corporation pays overtime wages at double the rate of basic, variable dearness allowance and house rent allowance per hour to the departmental workers for doing work beyond the fixed duty hours. The rate of overtime wages is as follows. Now that's substantial. However, the so-called contract workers are not paid any overtime wages. The so-called contract workers are paid at a flat rate as mentioned here in above, irrespective of the duration of work. Now please consider paragraph 21 at page 16, 16. But this is apropos your lordship's query. No normal limit regarding number of bags has been prescribed for the so-called contract workers. As a result, the so-called contract workers used to get the fixed rate of payment as mentioned in annexure P3 above, irrespective of quantity of work done. In that process, the so-called contract workers are being deprived from the incentive wages, overtime wages, and other fringe benefits apart from time scale of pay, as or was granted to the departmental workers doing the same equal and similar kind of job. But what could be a qualitative difference in handling job? That's nothing.
So they were getting paid at a flat rate, no
Yes.
matter what the number of bags they lifted.
A minimum guaranteed wage.
No, the contract workers were getting paid at a flat rate.
Flat rate means that that 8.15 rupees per bag. 8.25.
Or 12.50,
Weighing
depending
up to
upon the
65
weight.
kgs and above.
Depending upon the weight.
And no overtime, suppose not for the purpose of earning an extra wage, say for the purpose of earning 600 rupees per day, he has to work for 12 hours. The
Because he's getting a flat rate.
The same output or a lesser output is being given by a departmental worker on overtime wages. He's doing the same work, but what is being deprived to a contract worker is this overtime wages as well. I work for 10 hours a day. He works for 8 hours a day. He lifts 60 bags, I lift 60 bags.
But he is getting incentive.
He is getting incentive and more minimum guaranteed wage.
And overtime.
And overtime. So at least he takes away 400 rupees more than me per day.
Yes, let Mr. Chattopadhyay come on the next occasion. He has to respond. He was here today, but maybe he has missed it. Ashu. Mr. Mojumdar, Learned Counsel, appearing on behalf of the petitioner, submits that the contract laborers are deprived of the scale of pay, are deprived of the benefits given to the departmental workers in respect of scale of pay, hours of work, holidays, and all other ancillary and fringe benefits. Full stop. The payment made to the contract laborers, stroke members of the members of the petitioner are in violation of the provisions of Rule 25 within bracket 2 bracket closed within bracket choto 5 bracket closed within bracket A bracket closed of the contract labor within bracket regulation and abolition bracket closed central rules 1971 full stop. In the writ petition, the departmentalization of the members of the petitioners union has also been prayed for, full stop. Prayed for, full stop. Next. No one represents the Food Corporation of India within bracket FCI bracket closed today, full stop. Let a notice of the adjourned date of hearing of the writ petition be served upon Mr. Chattopadhyay, learned advocate representing the FCI, and a proof of service be filed on the adjourned date of hearing. Stop. Next. Let the matter appear under the same heading hearing hold on Next date of August 3, 2023.
August.
Please inform Mr. Chattopadhyay. Give a notice.
Second of
Third, second. I'm hearing Thursday. Nahi bola.
Lord, kindly that we have filed the affidavit in reply. Lord.
To the CAN application. Now I am not hearing the CAN application anymore. Anyway, likhe din. Affidavit in reply. Eta prothome.
But we may be seeking leave to rely on certain documents from this.
Affidavit in reply filed in CAN 4 of 2022 is retained with the records.
Grateful.
Why have you filed in CAN 4?
No, that was in aid of the main reputation because but these documents are very important in the sense
You
if
could
has
have
now
filed
taken
a supplementary affidavit in the writ petition. CAN 4 I'm not hearing anymore.
kindly
All right.
consider this as part of materials.
Grateful.
We have taken a decision to replace the departmental workers by contract laborers. So it helps my case.
Now they're only engaging contract laborers because of your injunction. Because of the injunction that you are enjoying.
No, it's all over West Bengal.
My writ petition. In the writ, my lord, we have an application for amendment, my lord, because the name of the petition has undergone a change. It was a limited company. It's now become a private limited company. We have filed. We have filed the application in 2022 after the name of the company has undergone a change. It's CAN 6, my lord.
No, where is your other side?
Mr. Prasad is there. But I do not think, my lord, there can be any objection to this, my lord.
There will be no objection, but where is he? You cannot deprive him of his appearance.
No, absolutely not, my lord.
Should you give a notice on him and come back? Mr. Tiwari.
Mr. Shailendra Tiwari was appearing and Mr. Shiv Chandra Prasad. Mr. Tiwari is for the Union of India and Mr. Prasad is for
the PF authority.
Yes, my lord.
Later notice of the writ petition indicating the adjourned date of hearing be served on the learned advocates representing the Provident Fund Authority as well as the Union of India, and a proof of service be filed on the adjourned date of hearing.
And my lord, affidavits have not been filed in the writ petition. There's also
Let them come.
very
Let them come. Let the matter appear for further consideration under the same heading for hearing on August 2, 2023.
August 14.
Two.
Very.
Next.
Very. I'm sorry.
I'm appearing for the petition in this matter. Plus, this matter relates to Employees Provident Fund and Miscellaneous Provisions Act. It pertains to damages under Section 14B and penalty under 7Q. The simple point involved in this case is that prior to 26/9/2008,
1 second.
for the period June 25, June 5, June 5, June 5, and June 5. That is prior to 2008.
Yes.
My lord, page 6. Lordship kindly comes to page 63.
Page
63.
Yes.
Now, proceedings of the order under Section 7A of the Employers Provident Fund, Miscellaneous Provisions Act. Now, the main portion of the order today was fixed for hearing under Section 7A for the period 4/4, 5/4, 6/5 of the establishments such and such, Sri Nigam Nilanjan Gupta, EO, representing the department, had submitted report dated such and such, confirming the dues position in the period of inquiry and accounts which is taken in record. Evident that, kindly see, it is evident that 7Q amount of rupees 7,90,976 has not been remitted by the establishment in spite of direction to remit the same immediately in order to dated such and such and produce the proof of remittance. Prior to, as I said, 26/9/2008, 14B and 7Q could not have been segregated. They should have been clubbed. Now, what happens in 2005? They segregate and impose the penalty of 7Q at the rate of 7,90,976. I'll cut short the matter by straight away judgment. Lord, I'll cut short the matter because it will be easier because there are established judgment on these issues.
Yes.
I did not. Your Lordship.
Employees Provident Fund. Yes. First place 7Q.
Shall I read out, Lord?
Yes, 7Q.
7Q. Boita dekh. Seven Q. Has your Lordship got that? Interest payable by the employer. The employer shall be liable to pay simple interest at the rate of 12% per annum or at such higher rate as may be specified in the scheme on any amount due from him under this act from the date on which the amount has become so due till the date of its actual payment, provided that higher rate of interest specified in the scheme shall not exceed the lending rate of the interest charged by any scheduled bank. The 7Q and 14B, my lord, may I read out for your Lordship?
Fourteen
capital B. B.
Yes.
Power to recover damages. Once the employer defaults, my lord, then the corpus of the employee suffers, and that is why these damages. Power to recover damages, where an employer makes default in payment of any contribution to the fund, the pension fund or the insurance fund, or in transfer of accumulation required to be transferred by him under subsection 2 of section 15, or subsection 5 of section 17, or in the payment of any charges payable under any other provisions of that, or of any scheme or insurance scheme under any of the conditions specified under section 17, the Central Provident Fund Commissioner or such other officer as may be authorized by the central government by notification in the official gazette in this behalf may recover from the employer by way of penalty such damages not exceeding the amount of arrears as may be specified in the scheme. Provided that before levying the recovering such damages, the employer shall be given a reasonable opportunity of being heard. Provided further
that the central board may reduce or waive the damages levied under this section in relation to an establishment which is a sick industrial company and in respect of which a scheme for rehabilitation has been sanctioned by the Board of Industrial and Financial Reconstruction established under the Section 4 of the Sick Industrial Companies Special Provisions Act 1985, 1 of 86, subject to such terms and conditions as may be specified in the scheme. If I can explain to your lordship, it's very simple. This fund I have to collect while I disburse salary, I have to collect